My lord, may I file the written notes of argument that I under.
Okay.
Your Lordship, may I permit to mention one matter for extension of interim order, Your Lordship. It is expiring on 13th March 2025.
Extension of interim order. In which matter?
No, Your Lordship.
I don't want to
Three,
see it.
three.
On which matter?
Three.
Group?
Three.
I don't have the determination of
Your
group.
Lordship, this is judgment. Is provided by you, Lordship.
I may have passed the order, but that is not the determination right now. I cannot extend the order. Move the appropriate bench having determination.
My lord,
Next.
may I be permitted to mention two matters?
Today is not the day of mentioning. What is the matter?
Group 1 for inclusion in the list.
Okay.
Madam, may I have your lordship's leave to mention an matter for correction of the order date, my lord. My lord, matter was order was passed on 7th of April in that virus matter of 45 years age. My lord,
Okay.
several matters. My lord, inadvertently, my lord, the date is mentioned as 4th of March in the order.
Okay. You give it to me. I am for Monday. It will appear. Monday. Next week.
Wednesday.
Next week. Wednesday.
Monday is the holiday.
Wednesday it would appear.
Just my lord, the first date of the order, my lord, is.
Call the list.
I'm grateful, my lord.
I am for the petitioner, your lordship. This is a non-prosecution matter. Petitioner does not want to proceed with the writ petition. This is the intimation.
Please take down. This matter appears under the heading of to be mentioned. Learned advocate on record, Mr. Shubham Das, submits that the petitioner doesn't want to proceed further with this matter. Mr. Das hand over the original written instruction of the petitioner. Let the written instruction be taken on record. Full stop. Having heard the learned counsel for the parties, considering the written instruction of the petitioner on prosecution, let the instant writ petition be disposed of as not pressed. Full stop. The interim order, if any, passed by this court during the pendency of the instant writ petition is hereby vacated.
Grateful. Grateful.
Next.
Yes, sir. I am for the petitioner.
Affidavit of what? আমার কপি দেননি তো?
হ্যাঁ,
কি কাকে দিয়েছে? কি হচ্ছে এগুলো? না না দাঁড়ান, আমি পাইনি, কাকে দিয়েছেন দেখছি আমি। আমি মিথ্যে কথা কেন?
তাকে দিয়েছেন যে সই করেছে তাকে দিয়েছি, যার নাম এতে রয়েছে তলায় রয়েছে তাকে দিয়েছি। এই যে ওই তো ওই তো
সব্যসাচী মণ্ডল তো আসছেই না।
সে তো আসছে না, সে তো আপনার দায়িত্ব। আমি কি করে বলবো? আমাকে বলছেন আপনি কপি দেননি, বলেন। আর আমি জানি না, দেখুন মানে আর কি আপনি যদি অস্বীকার করেন।
না না, আপনি এত ঝগড়া করেন কেন কোর্টে? আপনার সঙ্গে কি আমার ঝগড়া আছে?
আমি মানে
আমি বুঝতে পারি না, আপনাকে আগের দিনও আমি ফলো করলাম।
আমি দিয়েছি, তারপরে যদি আপনি বলেন যে মানে কি
আমি বলছি, মানে আমি যেটা বলছি সেটা ঠিকই বলছি। What I said, it is not the incorrect. This copy has not yet reached to my hand. My lord, the clerk of
both of you are correct. Both of you are correct.
I am not,
but circumstances is otherwise.
There is no scope for any further for it.
Yes,
my lord. These my
so
lord.
What can be done today? Can you start? Can we start today?
I can. My junior is not coming in court for last.
I understand your difficulty.
Because of his, my lord, because of his accident, he is, my lord, bedridden for last more than fortnight. He is not coming in court. Now, my lord, his clerk, in any event, my lord knows that, received it, and it has not been, neither it was informed to my junior, nor handed over to me. I am not denying, I'm not saying this is not correct. In any event, my lord, without, my lord, I do not want to even go through the affidavit because whatever I have said in my petition, that is some factual aspect with regard to the knowledge of myself and my clerk. Because this is my application for restoration, not restoration, recalling of my lord's order under Order 9, Rule 13. Here I have stated that under what circumstances, my lord, we could not appear before your lordship on that particular day. All of us missed the list and we could not appear. Now, if your lordship kindly have a look, my lord, these certain paragraphs. After all, these are all the, my lord, the procedures. The procedure, there are provision under the statute and, my lord, we are just resorting to that procedure. Now, whether this will be allowed or not, that will be up to your lordship.
No, the issue is that whether the authority has used the affidavit in this matter.
My lord, may I tell? An affidavit was affirmed, if your lordship kindly, yes, my lord, kindly have a look. My lord, D and one paragraph. Affidavit already annexed here. Lordship, kindly have a look, my lord, the paragraph number 6 of my application for recalling of my lord's order. এদিকে ও আসছে না, আমার নাম্বার দিয়ে দিও না। Have you lordship got it, my lord?
Yes.
Number 6. The applicants humbly submit that the respondent authority is always aware and still are willing to contest the above writ petition on diverse grounds, which is evident from the fact of affirmation of an affidavit in opposition by one Sri Priyanjan Das, the then Deputy Managing Director of the respondent number 1, that is CSTC. On 15th of December 2020, it was affirmed. On behalf of the respondents dealing with the amendments made in the said writ petition, thereby denying the claim of the writ petitioner. Since bearing the date of said final hearing of the above writ petition, the above matter had never been taken up before any other coordinate bench after the date of affirmation of said affidavit in opposition. It could not be filed in court, but a copy of the same was served upon the learned advocate Srimati Susmita De Basu, who normally in most of the cases used to appear on behalf of writ petitioner against the present applicant's respondents, and who accepted the copy of said affidavit by putting her signature on another copy of said affidavit. My lord, what happened? Susmita De Basu appeared, my lord, at least out, my lord, 90% of the matters against, my lord, Calcutta State Transport Corporation. Now, my lord, my clerk served this copy of the opposition also upon Susmita De Basu, who accepted them, the said copy. Now, my lord, it appears from the affidavit in opposition copy that he received it. Request lordship kindly have a look. See, my lord, the this opposition affirm annex. Lordship, the last annexure. Last annexure.
Yes.
The opposition affidavit in opposition on behalf of respondents, and at the left hand side top received the copy on 8th February 2021 at 2:10 p.m. S. De Basu advocate. Now, my lord, by mistake, my lord, that's my clerk also thought, or my junior's clerk thought, that Susmita De Basu was appearing in this matter, served it, she accepted it. But we could not file the original because of the fact that we could not, my lord, appear before your lordship on that very day. And it is with us still. And the copy we again, my lord, annexed to it. Now, my lord, if your lordship kindly have a look, some paragraphs, my lord, I have stated in my lord application for recalling. Paragraph number 3, paragraph 2, 3 onwards. Paragraph 2 is the, my lord, the knowledge to the fact of the order passed by your lordship for the first time after the copy of the letter along with the order served upon the CSTC on 8th of August 2024 at paragraph number 2. And then, my lord, the explanation given for non-appearance before your lordship by the respondents, that is, my lord, paragraph number 3 and onwards, that the concerned officer of the applicants immediately thereafter made contact with their advocates, was briefed in the matter to contest the said proceeding, and sought for information about their failure to represent the applicant respondents in that matter on that day. And in response to the said query, both the advocates engaged to contest the above matter informed the applicant respondent that though the said matter duly appeared on diverse dates on the cause list of the said honorable judge, but both of them unfortunately missed the matter in course of their routine verification or check up the cause list on all these dates. And as a result of which it was not in their knowledge that the said matter was appearing in the cause list of the honorable judge, and in view of above, none of the said advocates were able to presented themselves on 1st August 24 before the honorable judge.
Yes.
Now, my lord, the rest of the is that, my lord, with regard to, my lord, the certain, my lord, the merits of the matter which we are denying. Now, if your lordship allow me, I can come to that merit. That with regard to that, because the merit in the matter is that, my lord, so far this appointment of trainee driver of the writ petitioner was concerned. In 2002, my lord, on 24 December 2002, now, my lord, the appointment was made in CSTC, 24 December 2002. Now, my lord, in the appointment letter also, we admit that there is a clause that the absorption would be in terms of as per 3rd August 79, memo number 1700 of the Labor Department memo.
Yes.
Now, my lord, that Labor Department memo, we have stated in our affidavit that Labor Department memo, which is annexed to the writ petition also, my lord, that is in respect of the, my lord, the employment in government, not this undertaking. Because undertaking, this employment in an undertaking is not a government servant. Because memo said that
But
the
there is a
government
clause in the,
now
there is a clause in your memo.
there is a clause. I am
Yes.
not denying. I am not denying, because what the fact is, I cannot deny that. I can only explain that how and why it is not applicable.
Yes.
Now, that also, my lord, so far that 1979 memo is concerned, it appears in that memo, not only that was applicable for government employee, but or casual employee engaged by the government, but there is that after the, my lord, introduction of the said memo, no further employment in any, my lord, temporary or casual status by any establishment by the government, and all such employment, if it becomes necessary, should be made through the employment exchange. It is there in the memo. His appointment is in 2002 December. So even if that memo is not applicable, even if it is, it's wide scope, if anybody can say it is wide scope implementation, even then, because the memo itself says, if your lordship allow me, I can draw your lordship kind attention to that particular annexure to the writ petition.
Yes, you can proceed.
My lord. Then, my lord, it appears, lordship, kindly have a look. Because solely on the basis of that memo, my lord, the writ petitioners, my lord, they relied upon, and my lord, the order was passed. My lord, if your lordship kindly come to the last annexure to the writ petition at page number 35. Annexure P5. Writ petition, lordship.
Yes.
Now, my lord, this memo was issued by the Labor Department on 3rd August 79. Memorandum subject principles to be followed in the matter of absorption of casual and such other category of workers under the state government. Now, she kindly consider this, under the state government. Now, CSTC is not the state government, it is an undertaking. My lord knows it's a settled law.
Yes.
That any engagement or employment by undertaking cannot, my lord, akin to the, my lord, equal to any state government appointment. Because their service rules, they are everything different. CST service rules are different, everything. Then, Lordship, Government of West Bengal, the contents of the memo.
Yes.
Contents of the memo. Government of West Bengal have for some time past been considering the question of discontinuation of employment of casual and such other categories of workers in perennial type of work, and the question of gradual absorption of all such categories of workers employed from time to time by the employing authorities under the state government, again, Lordship. After careful consideration of the matter, it has been decided as under: further recruitment or casual and such other categories of workers shall not be normally made. Initial recruitment of such workers, if considered unavoidable by any employing authority, shall henceforth be invariably made through the employment exchange, as already decided in the case of filling up of vacancies of non-PSC, non-promotional post. Ad hoc appointment of persons from the open market may, however, be made for a period not exceeding 15 days to meet any situation of emergent nature. Such ad hoc appointees will have no claim in future for absorption in the regular establishment under the state government. Again, on the diverse paragraphs, my lord, the expression is that a state government, it is casual and such other categories of workers who have been engaged in a perennial type of work. That means on the day when the memo was issued in 79, who have been engaged, already engaged for a continuous period of more than 3 years. That means before 79, there should be a 3 years continuous, may be absorbed in the regular establishment on temporary basis in existing vacancies. If suitable vacancies are not available, necessary steps may be taken by the respective authorities to create the requisite number of posts for the purpose of absorption of such categories. That means, my lord, the supernumerary post. But for those who on 79 December already there, my lord, for more than 3 years, and that too in a government establishment. So, my lord, on the basis of this, my lord, may I tell you one thing? My lord, today that judgment is not with me, but my lord knows that even if, my lord, that was a clause, my lord, it appears in there, my lord, the appointment letter, petitioner's appointment letter. My lord, yes, it is there, lordship, page number 19. The appointment letter, it is there, that
Yes.
particular clause, page number 19. Clause number Roman 12.
Yes.
Question of absorption in regular establishment would be considered as per provisions made under GO number 1700 EMP dated 3rd August 79, read with circular number such and such, on completion of 720 days satisfactory duty from the date of engagement as deliberated trainee worker according to availability of vacancy. Now, my lord, only thing, may I tell one thing, lordship, that my lord knows that if it is the basis of my lord, the plea of promissory estoppel on the part of the petitioner, my humble submission is that promissory estoppel against a government or, my lord, the government organization or a government authority can only, my lord, to be taken up as a, my lord, my lord, the any attack on the basis of that this a promissory estoppel, one has to comply. My lord, there are settled principles of law that there cannot be any promise against the statutory provision or against my authority. My lord, no promise can be made by any authority, my lord, against the statutory provision, or that may go beyond his authority, that where he has no promise to do that. Because the sole basis or foundation of the writ petition is this: at the, my lord, Bharj office retirement, it appears, or, my lord, he already retired, maybe during
Already
retired, that this is a promise. Now, my lord, my humble submission is this, my lord, I can place before your lordship, but I'm very sorry that judgment, because I thought that, my lord, the merit may not go today, but I thought but I can place before your lordship any day those judgment, and my lord knows that promise on behalf of an authority can only be based and or valid promise if it is, my lord, backed by any statutory provision. Otherwise, my lord, that is not a promise to be relied upon by the person who says that the offers have been made to me. That cannot be an offer, or that cannot be a promise, because it appears from the, my lord, that particular geo itself, that it is, first of all, it is applicable. কি আশ্চর্য, ফোনটা স্মার্ট, লোকটা তো স্মার্ট নয়, কি করা যাবে? Now, this is the, my lord, the problem generated on the basis of this provision, no doubt. But my lord, in a court of law, lordship, kindly see, in a court of law, my lord knows that if there is any conflict between, my lord, the equity and the legal provision, then my lord knows also, it is also tried law that the legal provision, my lord, that will survive, but not the, my lord, the equity, because read code is a court of equity, no doubt about it. Now, his right flows from this, my lord, naturally, my lord, based on the proper, my lord, the perspective and the, my lord, the object and, my lord, the meaning of the said or scope of the said memo. The memo does not give any right to the authority to say that, the CSTC authority, neither, my lord, there flows from any right accrues from that on behalf of the petitioner, so far that particular memo. So, my lord, my humble, my lord, submission is this, that so in our opposition, my lord, we have stated that. We have,
What you have stated in your opposition? Refer me.
my lord,
What is your case in the opposition?
on opposition, yes. It is, my lord, annex 2. But, my lord, the original is with me.
Very well.
If
We
you
can
lordship
proceed.
allow me, I can.
Yes, we can proceed with the.
But so for the copy is concerned, my lord, that is, my lord, annexed here too.
Yes,
Annexed step to my,
Annexure 3.
yes. Now, my lord,
Annexure
kindly have a look.
Yes.
My stand, what, my lord,
What is your stand?
yes. My lord, page 4,
Yes, inner page 4.
inner page 4, my lord, at the middle portion, so far the petitioner's claim, have you lordship?
Yes,
So far the petitioner's claim for permanent absorption in regular establishment of the respondent corporation is concerned, the same has been denied and or strongly opposed by the respondent corporation in case of other similarly situated contractual casual employees of the corporation. And similarly, at the present instance, the said demand for permanent absorption raised by the petitioner is equally rejected and or such claim is denied on the following diverse reasons. 1. The petitioner, after having accepted the offer to render his services in the respondent corporation as trainee delegated driver cum conductor, has no legal right to claim for permanent absorption in regular establishment of the corporation. The offer made to the petitioner as well as his acceptance to work as delegated trainee driver cum conductor was not against any sanctioned post in the respondent corporation. My lord, may I pause here for a moment? My lord, it is also a tried law that, my lord, the absorption to a regular post only, my lord, appears for consideration if the original or initial appointment was made against a sanctioned post.
yes,
There are so many, my lord, the judgment that even, my lord, the length of service as a temporary or casual, that would not create any such right unless the initial engagement was against any sanctioned vacant post. Now, it is nobody's case that it was against a sanctioned vacant post. Then, my lord, 3, the petitioner's such engagement in the corporation was not preceded with compliance of prevalent prescribed norms and procedure to be followed in case of appointment to a regular sanctioned post in the respondent corporation being one of the transport undertaking of the state formed under statute. Then the financial health of the respondent corporation is not stable to bear the burden of salary. I am not on that, brother. I'm being. Now, my lord, kindly come to page number 6, Roman 8.
Yes,
The provisions for regularization as mentioned in circular GO number 1700 EMP dated 3rd August 79 has not only negated by and or modified by subsequent circular GO issued by the Labour Department, Government of West Bengal, but the tenets and scope of such provision contained either in the said circular dated 3rd August 79 or in other circular of 2000 have lost their respective force. Now, my lord, kindly come to paragraph number 5 once, lordship. Page 2. Paragraph 5 at the bottom. Page 2.
yes,
With reference to the statements made in paragraph number 4 of the said petition, that means my read petition, because this is opposition, quoting clause number Roman 12 of the letter of such contractual engagement, I state that, first of all the scope of provisions for regularization subject to several terms and conditions mentioned in said GO number 1700 of 79, issued by Labour Department of Government of West Bengal, was restricted to the contractual or casual workers who had already been engaged under the state government, and the same is not applicable to the petitioner whose engagement in the corporation was made by issuance of a letter of engagement dated 16 December 2002, and that too not under the state government, since none of the employee of the respondent corporation, whether casual, contractual, and or permanent, enjoys the status of state government employee. Apart from that, the scope and doctrine expressed by the said circular of 79 has also lost its force in view of several subsequent GO or circulars issued by the Labour Department of Government of West Bengal covering the said field. And further, whatever scope of regularization of casual or contractual workers was floated by the said circular dated 3rd August 79, the same has been negated by the catena of judgments delivered time to time by the Honorable Supreme Court. Without waiving the above contention, I further state there is no declared vacancy in the position or status in the respondent corporation wherein the petitioner has been rendering service.
so this is the stand.
This is the stand. Now, my lord, under these circumstances, my lord, if there is any merit, Lordship kindly consider, with regard to the, my lord, the stand of the corporation, subject to any further hearing, then my humble submission is this, because there are some judgments also, my lord, with regard to that, my lord, the regularization. Then, my lord, kindly, my lord, give this transport department an opportunity of a full-fledged hearing in the matter. Lordship kindly recall the order.
No, I am conducting the hearing of this matter. I am allowing you to hear.
Then,
If
my
you
lord,
want any time, I can give you the next day. No issue. To prepare the judgments you
yes,
want to
yes,
judge.
my lord, my lord.
I started hearing.
Very good. I'm grateful to your lordship. I'm
Yes.
grateful.
So
Except, my lord,
I can only
Except
only
next to-
allow the can
my lord.
if there is a merit on your matter.
That's my lord. And my lord knows that, my lord, for last, my lord, I think last 5 to 6 years, or maybe some more. Even in case of, my lord, because the earlier, with regard to the, my lord, the limitation when it appears, that condonation of delay, there was a strict compliance to the, my lord, the satisfaction with the explanation given
Yes.
in the condonation of delay. Now, my lord, it appears from the several judgments of the Apex Court and our High Court also, that suppose, my lord, there are 3 or 4 or 5 years delay, but still merit is there. So then, my lord, the merit would merge over the, so here, if your lordship allow me, then, my lord, I am very, my lord, grateful to your lordship. I can come any day with those judgments, except the, my lord, the next week. Next week, my lord, I will not be here, my lord.
Next week?
My lord, I have to leave the station. I have to go to Hyderabad for some medical checkup. Any day,
Very well.
except next.
So, let me hear it out. Yes.
Yes, I'm
First
grateful
time
that
we
your
have,
lordship
first time we have,
call from your lordship that whether there is a merit in the application itself. First, it will be decided.
Yes.
That merit in the read matter which is non-existent because your lordship delivers judgment and they are want to recall it and they are preferring the what merit is they are not. I do not say. Your lordship kindly see. Your lordship kindly see paragraph 1. Take their application.
yes,
The application is being made by the respondent in terms of the provisions under Order 9, Rule 13 of the Code of Civil Procedure, praying for recalling such answers.
yes,
Well, the answer I have given, paragraph 5. Where? Paragraph 5, page 3.
of your opposition.
Opposition.
বড়রামকে ফোন করো লিখে দিয়ে অ্যাফিডেভিটটা দিয়ে দিয়েছে
Yes,
I say that this application filed by the respondents under Order 9, Rule 13 of the Code of Civil Procedure for recalling the order dated such and such passed by the Honorable Justice Shubhendu Samanto in the impugned proceeding is not maintainable and deserve to be dismissed. Because in a writ proceeding, application made categorically is not maintainable, I further say that recalling the application is also not maintainable. But your lordship can see the provision of 141 of CPC. May I get that? 141.
yes,
Your lordship kindly see the explanation. That statute said in the writ proceeding, CPC does not applicable. You will kindly see that. It is made by the legislature.
এটা এখন শিখতে হবে।
okay,
You have to see. And your lordship kindly see the paragraph 4 of their application.
paragraph 4,
4 of their
okay,
application. Yeah, they have said in response to the said query, both the advocates engaged to the contest your lordship has seen the answer I have given, my lord. I say that procedure adopted for mentioning this matter before this honorable court was that notice should be served upon the respondents before mentioning and upon following the said procedure. The matter was mentioned thereafter and thereafter duly appeared just together as such answers. But the two learned advocates appearing for the respondent did not appear, and as such there was no alternative open to the honorable court but to pass the order on merit, even if expert. And at this juncture, the respondent cannot take advantage of their own failure to appear before his lordship.
yes,
And my lord, they have said they have given, my lord, your lordship can read paragraph 6. Paragraph 6 of their application. May I read, my lord? The applicant submits that the respondent authority is always loyal and is willing to contest the above application on diverse terms, which is evident from the fact affirmation of an affidavit of opposition by one CPM the circumstances. Managing Director of the respondent number 1 on 15 December 2020. On behalf of the respondents, dealing with the amendments made in the said petition thereby denying the claim of the petitioner. Since bearing the date of said final hearing of the above petition, the above matter never taken up before any other coordinate bench after the date of affirmation of said individual position. It could not be filed in court, but a copy of the same was served upon the learned advocate Srimati Sushmita Devasu, who normally in most of the cases used to appear on behalf of the petitioner against the present application respondent, and who accepted the copy of the said affidavit by putting a signature such and such. Your Lordship, my answer is 9.
Paragraph 9.
Paragraph 9, page 4. Your Lordship, turn to next page. I state, page 5, I state that this statement is incorrect and no copy of the affidavit in opposition was ever served to the petitioner or his learned advocate. At no point of time, Srimati Sushmita Devasu, advocate, was engaged by the petitioner or appeared for the petitioner. The statement is false and made with an ulterior motive to defraud the petitioner. I say that the respondent should prove the statement made by them, failing which this honorable court will take appropriate steps for the false statement. And Your Lordship, hereafter, my lord, they have said what is the merit of the case. This cannot be said because the petition is not before the Your Lordship. It is only this application.
Yes.
And my lord, what I have said, when Your Lordship has seen that the CPC is not applicable, my lord, Your Lordship knows that in the case of HON'BLE versus RS Knight, 1988, this is clear that only the legislature can pass that any statutory order, but no court has the power to pass an order, go beyond the statute.
Yes.
And only will give you the hand over the copy. Here, this is HON'BLE versus 7 judges bench. But it is 1988 to SCC 602. It is presided over by Justice Subhash Mukherjee. So he knows the fact. It is a 1988 case, and it is one of the great cases before
Yes.
the Supreme Court. That no one will prejudice by the court, and the court cannot make a law in its own, even the Supreme Court. If that is so, they have made when the application is barred under the CPC, they have made it intentionally under the CPC. So this application is void ab initio because of the statute of CPC 141. It is 7 judges bench, my lord. If any Supreme Court says yes, principle applies, that says the 7 judges bench have been overruled.
Okay. That's all?
Sir,
Okay.
there is no merit.
Very. Mr. Sen, come on, reply on 21st.
My lord, only my lord.
21st?
My lord,
No, you come on 21st.
my lord,
Only.
in answer to this question, my lord, this is our, my lord, the Article 226 of the Constitution of India rules. This rule, my lord, we have to follow. My lord, this rule, my lord, enunciated by our High Court, Calcutta. This is our, my lord, the Article 226 rules to be followed in both, my lord, appellate side and original side in any proceeding under Article 226. Now, my lord, kindly have a look at Rule 53 of the Article 226 of the Constitution rule. Rule 53 speaks, 7 except as provided by these rules, subject thereto, the procedure provided in the Code of Civil Procedure in regard to suits shall be followed as far as it can be made applicable in all proceedings for issue of a writ. That's a kindly we have to follow this. Rule 53 of our appellate side rule.
Application under Order 9, Rule 13, specifically.
Rule 53 of our High Court's Article 226 rules. Can anybody, my lord, say that no, this rule is not applicable, at least in this present proceeding?
Yes. Okay, come on next day.
My lord.
Argument on behalf of the parties, argument on behalf of the behalf of the petitioner within bracket লেখো can 1 of 2025 না প্রথমে লেখো affidavit in opposition by the petitioner against can 1 of 2025 is taken on record, full stop. Argument on behalf of the petitioner within bracket can 1 of 2024 heard. The respondent within bracket read petitioner also submits the merit of the application,
ছবি নিতে পারি
submits regarding the merit of the application.
তার কাছ থেকে কপিটা উদ্ধার
Let the matter be fixed on 21st of April 2025 for a reply on behalf of the CSTC, on behalf of CSTC.
আমি তো তাকে চিনি না
কি করবো বলুন, মানে আর
না
কি?
না আমি অস্বীকার তো
আমাকে-
করছি না কি মুশকিল
না না, আমিও কিছু বলছি না আপনাকে।
আমি কেন অস্বীকার করতে যাবো শুধু তার কাছ থেকে কপিটা তো উদ্ধার করতে হবে
সে করুন না, নিন না। আপনি যদি চান এটা আপনাকে দিয়ে দেবেন, কি বলেন?
বাস থ্যাংক ইউ
Come on Monday,
ম্যাডাম,
Monday week.
you reply. Monday means Monday week,
মার্কেট
21st.
গেট
এই ভালো।
Well, I am appearing for the petitioner in this contempt petition. And my learned friend is appearing for the applicant. For the
Hello, remembers, these are recalling applications filed by the state on the score of suppression of material facts. Will kindly come to page 16. Should I proceed, Milord?
No, the matter of maintainability has been raised by the.
I'll show, Milord. I'll show.
Yes,
I'll show.
that is, we are.
I'll
carrying-
show. I'll show. I'll show
Wait,
everything,
wait.
Milord. I'll show
Yes.
everything, Milord. I'm duty bound to assist the honorable bench, Milord. I'll show everything. Page 16, Milord. I'm showing this order, Milord, just to show the way in which the matter was conducted before your lordship. Your lordship has the copy of the application?
Application, read petition,
No, recalling application,
can 1,
can one.
yes.
I will kindly come to page 16.
Yes,
This is the order, Milord, we are praying for recalling of. This is an order dated 10th of December 2024. I will kindly turn the page, Milord. Here, Milord, the state has terminated or the license on the basis of a clause. Look, page 17, Milord, kindly come to last paragraph I'm reading from here, Milord. Mr. Such and such, appearing on behalf of the petitioner, submits that the observation of the district controller food and supply is dehorsed the law declared by this court. He submits that the same issue has been raised before this writ court in such and such. In the said writ petition, the petitioners therein have challenged the similar vacancy notification of identical date but different blocks, challenging constitutional validity of clause 1, 2, 7, and 8 of the said notification. The clause 7 of the notification which was under challenge before this court in WPN number such and such is identical to clause 7 of the impugned notification being notification number such and such. Mr. Agarwal, Mr. Such and such submits that when this court has declared a clause of a notification to be ultra-virus and which was struck down, the district controller concerned authority is legally not empowered to dispose of any representation citing said clause in the said notification. He further submits that the authority has acted illegally and only to show the grudge against the present petitioner has passed the impugned order denying MR distributorship in favor of the present petitioner. Learned counsel, appearing on behalf of the state authority, submits that the impugned clause 7 was not challenged before this court. So in the present proceedings, the impugned clause was not challenged. What he insisted, my learned senior counsel has insisted, is, my lord, the clause was already declared ultra-virus in another proceedings. So the authority could not have insisted or relied upon the said clause. My lord will kindly turn the page. Last paragraph, my lord. Lord, the court does not go to the merits of the matter on relying on the submission of the petitioner that this clause was declared ultra-virus. My lord will kindly, last paragraph, is my lord's observation. I make it clear that when a clause of the notification has been declared before this court to be ultra-virus, and as this is of great importance, my lord, as the state authority has not preferred any appeal against the said order, the order passed by this court becoming binding upon the state authority, the state authority now again cannot deny the eligibility. My lord, what I am on today is, my lord, it's the same advocate on record. My lord, there is an appeal against the order where same counsels have appeared. So it was well within their knowledge that state has preferred an appeal and the judgment impugned as relied upon by the petitioner is not a judgment in rem. I have records to show that same counsel as has appeared in this writ petition had appeared in the appeal preferred by the state government. Now, my submission is twofold. My submission is this state has preferred this appeal was well within the knowledge of the petitioner. My lord, suppressing such fact tantamounts to fraud. My lord, fraud vitiates everything. My lord, my learned friend has taken this point of maintainability. I need to first address on that. May I, my lord? These recalling application, my lords, exercises my lord's inherent power under section 151.
Yes.
My lord, straight away come to my lord. This is 1999 4 SCC, page 396. Paragraph 6, my lord, will straight away come to. Should I read it for your lordship, my lord? May I, my lord?
Paragraph,
Paragraph 6, my lord.
para 6, yes.
What is a power to recall? Inherent power to recall its own order vesting in tribunal or courts was noticed in Indian Bank versus Satnam Fibers. Wide Paragraph 23, this court has held that the courts have inherent power to recall and set aside an order obtained by fraud practiced upon the court. My lord, when the court is misled by a party, when the court itself commits a mistake which prejudices a party. My lord, I am on 1 and 2, if not 3. My lord, I say it is a fraud on the court. It is suppression. My lord, why fraud? My lord, I'll show that. I'll come to that judgment also. That suppression tantamounts to fraud. What amounts to fraud, my lord? I rely on another judgment of the Honorable Apex Court. But I am on Roman 1 and 2. Obtained by fraud practiced upon the court. Whether the act, as I have alleged, my lord, tantamounts to fraud or not, I'll demonstrate.
Yes.
When the court is misled by a party. So, my lord, he knowing very well that there is an appeal, he does not disclose this to the court, and he says this notification clause 7 has already been declared ultra-virus. State has not, he does not disclose the material fact that state has preferred an appeal against this order, though it is well within his knowledge. My lord, he conducts the procedure and gets a favorable order from the court. My lord, I'll read thereafter, my lord.
Why state has not mentioned?
Lord, it is definitely a lacuna on the part of the state, but my lord, with deepest of respect, I'll say, my lord, at least the state councils were not same councils did not appear. So it's a mistake bona fide on the part of the state. With deepest of respect, my lord, I'll say this. Not so in the case of the petitioner. If same councils have appeared, my lord, it will be presumed that it was well within their knowledge. Well, I'll read further, my lord. In AR such and such, my lord, this court has noticed motion to set aside judgments being permitted where a judgment was rendered in ignorance of fact that a necessary fact, we are not, my lord, this is not applicable in our case. A judgment was obtained by fraud. Now, my lord, I will try to establish that the act of suppression is, my lord, tantamounts to a fraud, my lord. But this is a single bench judgment of the Madras High Court. Of course, my lord, this does not have this has a persuasive value, your lordship knows. But, my lord, why I am insisting on this, my lord, this will save my lord's time. It has recorded the settled issue of the Supreme Courts, giving the citations. 2016 SCC. My lord, I am not relying on this judgment, but I am relying on the judgments referred in this judgment. 2016 SCC online Madras 33792. Kindly come to paragraph 25 onwards. Paragraph 25, my lord.
Yes.
It is thus settled proposition of law that a judgment, decree, or order obtained by playing fraud on the court, tribunal, or authority is nullity and honest in the eye of law. Such a judgment, decree, or order by the first court or the final court has to be treated as nullity by every court, superior or inferior. It can be challenged, my lord, kindly take note of this. It can be challenged in any court at any time in appeal, revision, with or even in collateral proceedings. In civil appeal number such and such, the Honorable Supreme Court has held. Well, this is the reason, my lord, it is giving the reference of the Supreme Court, my lord. This will save my lord's valuable time. I will not place 10 judgments, my lord. This will cover everything. In such and such, it is quoting, my lord, paragraph 25. So far as the second principle noticed by us is concerned, there is no doubt, my lord, the Supreme Court judge, this is the 25 of the Supreme Court judgment. There is no doubt of authority. Fraud vitiates all solemn acts. When an order has been obtained by practicing fraud on the court, it will be nullity. In my lord, such and such, reported in 2008, 12 SCC, page 353, this court held. It is now well settled principle that fraud vitiates all solemn acts. If an order obtained by reason of commission of fraud, even the principles of natural justice are not required to be complied with this setting aside of the same. So your lordship need not, today call upon the petitioner to substantiate their case, my lord. The natural justice will be given a go-by if I can establish that they have committed a fraud on the court. Well, in such and such, my lord, paragraph 21, when a fraud is practiced on a court, the same is rendered nullity. It goes on repeating the same, my lord. Not one, it gives many authorities. My lord will kindly, paragraph 16 is quoted, my lord, starting with reference Second paragraph of it, my lord will kindly take note of, it can be challenged. My lord, it says, it is that thus settled proposition of law that a judgment, decree, or order obtained by playing for fraud on the court authority tribunal is a nullity and honest in the eye of law and has to be treated as nullity by every court superior or inferior. It can be challenged in any court at any time in appeal, revision, or even in collateral proceedings. Paragraph 17, my lord, it is quoting, the court defined fraud. My lord, kindly take note of this. The court defined fraud as an act of deliberate deception with the design of securing something by taking unfair advantage of the other. My lord, I'll reread this. My lord, kindly allow me, my lord. The court defined fraud as an act of deliberate deception with the design of securing something by taking unfair advantage of another. In fraud, one gains at the loss and cost of another. Even the most solemn proceedings stands vitiated if they are acquitted by fraud. Fraud is thus an extrinsic collateral act which vitiates all judicial act, whether in rem or in personam. My lord, paragraph 27, my lord, in such and such, it quotes, my lord, paragraph 22 of that judgment. The judiciary in India also possesses inherent power, especially under Article 151, to recall its judgment or order if it is obtained by fraud on the court. Now, my lord, the question will come whether the act of suppression tantamounts to fraud or not, my lord. Now, kindly turn the page, my lord. Again, my lord, it is paragraph 28, my lord, will kindly come to. Counsel for the plaintiffs relying on the judgment of the apex court in such and such, wherein this court has held, coming to the question as what amounts to fraud, what amounts for securing a judgment by playing fraud in the court in such and such, this court categorically held that the non-disclosure of all necessary facts tantamounts to playing fraud on the court. Milord, I am on this, Milord. It was well, Milord, when within the knowledge of the petitioner that state has preferred an appeal and he takes the court for a ride, he says this clause has been declared ultra vires by in another proceedings, he suppresses the very fact to gain over the state. That state has preferred this appeal, though this fact was very much within his knowledge. Lord, I'll read this once more, my lord. Coming to the question as to what amounts for securing a judgment by playing fraud in the court in such and such, this court categorically held that non-disclosure of all necessary facts tantamounts to playing fraud on the court. At paragraph 6 of the judgment, it was held as follows. If he withholds a vital document in order to gain advantage on the other side, then he will be guilty of playing fraud on the court as well as on the opposite side. Your Lordship has seen, Milord? Milord, this is my understanding, Milord. It goes on and on, Milord. I will not take my Lord's valuable time on this, Milord. Paragraph 31 only, Milord, it quotes another Supreme Court judgment. I'll rely, Milord. It goes on, Milord. In between the paragraphs, it deprecates the act of fraud, Milord. Paragraph 31, Milord, will kindly come to. Yes. In civil appeal, number such and such, the Honorable Supreme Court held as follows. Yet in another decision, such and such, it was held that no court will allow itself to be used as an instrument of fraud, and no court, by way of rule of evidence and procedure, can allow its eyes to be closed to the fact it is being used as an instrument of fraud. The basic principle is that a party who secures a judgment by taking recourse to fraud should not be enabled to enjoy the fruits thereof. I will not take my lord's valuable time much. Lord, rereading this, my lord, this is my, I have two limbs of submission, my lord. I say, my lord, the judgment impugned, my lord, was obtained, my lord, suppressing material facts before the courts, which was well within the knowledge of the petitioner, my lord, and the such suppression, my lord, has tantamounts to fraud, my lord. I pray for recalling of the order, my lord. I'll pray for affidavits have been filed, my lord. I filed from the record, my lord. I'll pray for rehearing of the matter, if at all, because I have other judgments to show, my lord, that if he practices fraud, the court is not obliged to hear on the matter on merits. I have a 3 pages judgment on that. If someone suppresses material facts before a court, my lord, court is not obliged to hear out the matter. My lord, I will not come to that stage on in subsequent proceedings. So far as the recalling application is concerned, my lord, I had made my submission. My lord will kindly consider the same.
Yes.
My lord, may I
Reply.
My lord, the word fraud. Who has committed the fraud? Who is the party to the litigation? My lord, my learned friend has placed the judgment, paragraph 6. Kindly see, my lord, what has been stated therein. A judgment was rendered in ignorance of the fact that a necessary party had not been served at all, and was shown as served, or ignorance of the fact that a necessary party had died and the state was not represented. This is not the case here. A judgment was obtained by fraud. Who has committed fraud? A question arises whether the advocate who has appeared for the state, if does not inform the court, where the state is a party, that an appeal has been preferred, then who has committed the fraud? An advocate who is appearing in several litigations is not expected to say everything before the court and cannot keep in mind what has been taken in the earlier so many proceedings.
I can record the statement.
Yes.
He has filed an affidavit. Your worship, kindly see the first writ petition, WPA 9680. Kindly take my lord the 71 item 7.
9712.
No, my 9680 is the first writ petition.
96.
If he taking my lords to the affidavit, my lord will argue
I am
the
not
matter.
going to. I am not going to.
Then do not rely on the
I
affidavit.
am not going to the affidavit. I am just seeing the order.
Yes.
Kindly see the order dated 11th November 2024. On the prayer of relate counsel appearing on behalf of the state is on the matter be adjourned today.
11th November.
11th November, my lord. This matter was adjourned on the prayer of the learned advocate for the state, so that he may take instruction whether any appeal has been filed or not. Earlier order,
Where from he is getting this? Where from he is getting this?
I have appeared on that matter. That's why, my
Well,
lord,
the
your
court will record it. My lord, kindly not allow such submissions to be taken, my lord. From a
My lord,
person who has
my learned
suppressed
friend,
the
my learned
material
friend is
facts.
not aware that nowadays live proceedings are there,
Yes.
and that can be seen whether he has not prayed for this.
Could have come
Your-
with that.
Don't interrupt in this.
Yes.
My lord, your lordship specifically asked the learned advocate for the state, have you preferred any appeal? Then the learned advocate stated that I will have to come with instruction, and he prayed for an adjournment. Then, my lord, on 18th again, this matter was adjourned. And then after this matter was taken up, only in March 2025, in the passage of 4 or 5 months, my learned friend who appeared at that relevant point of time did not take any instruction as to whether the appeal has been filed or not. So who has committed the fraud? I ask myself, my lord. Now, my lord, secondly, even if an appeal is filed, there is no stay, and I place the judgment for lordship, my lord, that is on 2003 CHN 178, para 12 to 14 on the last occasion I placed it. My lord, even an appeal is filed and admitted. Has lordship got my 2003 CHN 178,
2003 CHN.
2007 volume 3.
2007, volume 3 CHN.
My lord, 178, para 12 to. The judgment is not with me. The lordship will kindly see paragraph
Paragraph 12.
12 to 14.
Paragraph 12 you referred.
Yes. My lord, the judgment is not present in my hand. Well, in this judgment, it has been. Sorry. 2007, no? 2007 3 CHN. Yes, yes. Para 12, my lord. At this juncture, it will not be appropriate to refer to the following observation of the Supreme Court in the case of Sri Chamundi Mopeds Limited versus Church of South India Trust Association, Madras, reported in AIR 1992 SC 1439, while pointing out the difference between an order of stay of operation of the order impugned and an order quashing the order itself. While considering the effect of an interim order staying the operation of the order under challenge, a distinction has to be made between quashing of an order and stay of operation of an order. Quashing of an order results in the restoration of the position as it stood on the date of passing of the order, which has been quashed. The stay of operation of an order does not, however, lead to such a result. It only means that the order which has been stayed would not be operative from the date of the passing of the stay order, and it does not mean that the order has been wiped out from existence. This means that if an order passed by the appellate authority is quashed and the matter is remanded, the result would be that the appeal would have been disposed of by the said order of the appellate authority, would be restored, and it can be said to be pending for the appellate authority after the quashing of the order of the appellate authority. The same cannot be said with regard to an order staying the operation of the order of the appellate authority, because in spite of the said order, the order of the appellate authority continues to exist in law, and so long as it exists, it cannot be said that the appeal which has been disposed of by the said order has not been disposed of and is still pending. We are therefore of the opinion that passing of the interim order dated such and such by Delhi High Court staying the operation of the order of the appellate authority does not have the effect of reviving an appeal which has been dismissed by the appellate authority by its order dated such and it cannot be said that after 21 February 1991 the said appeal stood revived and was pending for the appellate authority. Therefore, the effect of the order of stay in a pending appeal before the apex court does not amount to any declaration of law. Your lordship will kindly mark, my lord. Even if there is a stay, that does not declare any law.
In
But-
the appeal in here, there is no such stay.
There is no stay. Even in the appeal, my lord, the pending, has my learned friend has pointed out, there is no stay. Even if there would have been a stay, that appeal is not binding upon your lordship in passing the order on the basis of the order of the coordinate bench. That is, I am on the merits, my lord, since my learned friend has said that an appeal is pending, this order should not have been passed. And so far as fraud is concerned, my lord, fraud has been committed by the state advocate, who even after taking 2-3 adjournments did not inform the court that an appeal is pending. In that appeal, I am not a party. Sonai Food is not a party. And an advocate representing so many cases cannot be alleged to have committed fraud. And no judgment shows that an advocate has committed fraud by not mentioning any age. That is the fraud of the party. If the party would have suppressed anything in their affidavit, then there would have been a fraud. Therefore, my lord, and what was the reason of waiting for 4 months? The lords will find that this order has been passed on 10 December 2024, and appeal has, this recalling application has been filed on 3rd, no, just a moment, my lord. This contempt filed on 11 March 2025. March 2025, this appeal has been filed. This recalling application has been filed.
Yes.
After filing up the contempt petition, when they thought that they would be caught in contempt, then they filed this recalling application only to save the skin. And your lordship, I have placed the judgment also that when a contempt is pending, no application appeal should be heard until the contempt is disposed of. They have received the copy of the contempt, though I would have not served, but it has been served on 10th March 2025, and immediately thereafter, on the second day, they have filed this recalling application. When they came to know that a fraud has been committed, they could have come before lordship immediately after getting the impugned order. Only to save the skin of the contemner, this recalling application has been filed. And I have placed before lordship, my lord, that recalling application cannot be heard after the matter has been heard, after hearing both the parties and after perusal of the matters in the affidavits. So there is no scope for recalling of the order, my lord.
Yes.
May I
Let him finish.
I have already placed, my lord, that recalling application can be accepted only when there is the order of dismissal or a party has not been have opportunity to be heard. But here both parties were appeared, time was taken, matter was adjourned, and then after the final hearing was done in presence of both the parties.
Okay.
My lord, first question is who played the fraud? By the way, kindly come to the judgment of the Madras High Court once again. Paragraph 26, my lord will kindly turn the page, my lord. 26, my lord will kindly turn the page. In such and such, the Honorable Supreme Court has held as follows, my lord. Within courts, my lord, the judgment of the apex court is noted, my lord. It is now a well-settled principle that
Yes.
kindly give me 1 minute. Paragraph 28, my lord will come. Kindly come to. Paragraph 28, my lord will kindly come to. My lord, I do not say, I say, my lord, recalling application is on the pretext of fraud. My lord, fraud of non-disclosing the fact that an appeal has been filed and insisting the Honorable Court to rely on a judgment where clause 7 has been declared ultra vires. So he conducts his case in such fashion to gain advantage over me. Paragraph 21. Coming to the question as to what amounts for securing a judgment by playing fraud in the court. In such and such, this court categorically held that non-disclosure of all necessary facts tantamounts to playing fraud on the court. At paragraph 6 of the said judgment, it was held, if he withholds a vital document in order to gain advantage on the other side. Milord, here, Milord, who had played the fraud, Milord, is coming from this paragraph. Milord, in order to gain advantage on the other side, then he would be guilty of playing fraud on the court as well as on the opposite party. So this answers to his query as to who played the fraud. Well, the state is not a fool that if 4 adjournments are taken on the ground of coming to inform this court, if an appeal has been filed, state will not assist the court with that fact. State has missed. The biggest of weapon available to the state at that time was, Milord, the fact that state has preferred in appeal. The state did not disclose it. There is no reason of state withholding such information if the learned advocate had knowledge. My lord, second, my lord,
No, whether in your affidavit you have stated,
my lord, even if my affidavit,
also not stated.
even if my in a affidavit, my lord, I have missed. Even if, my lord, I have missed.
No, neither, even.
No, even, my lord will appreciate this. I am not on merits of the matter. My lord will hear out whether the appeal court had stayed or not is a different question. Were we not obliged? Was he not obliged to place before the court that yes, when he is relying on a judgment, he does not know that an appeal has been, he is relying on that very judgment. He is insisting on the judgment. Is it believable that he will not assist the court with the fact that state has preferred an appeal against that order? What will you consider? My lord, he says, my lord, the delay. For delay, my lord will kindly come to paragraph 26.
Paragraph 26 of what?
Paragraph 26 of this judgment only, my lord.
Yes.
But where it says, my lord, in the middle, my lord, middle portion of the page, my lord, it can be challenged in any court at any time. This is the answer, my lord. If I have discovered fraud, suppression amounts to fraud, my lord. This is my humble submission. This is my argument. Now, if I have discovered it, my lord, I can challenge it at any point of time and it will vitiate all. My lord, I am not asking your lordship not to hear out the merits, matter on merits. All I am praying today is, my lord, will kindly hear out the matters on merits, because materials that were required to be placed before your lordship was not placed. Material suppression was there. That has tantamounted to fraud. Whether the appeal court has stayed the order or not will be considered when the my lord considers the matters on merit, not at this stage. This is my submission. My lord will kindly.
Yes.
Only one, I won't take any time, my lord, and I am not giving reply. I am just only pointing out your lordship, my lord, that my learned friend is saying fraud, fraud, fraud. Fraud is to be proved beyond doubt.
Of
There is
course,
no
lord,
fraud. Just a minute. And what is the answer of recalling and review? Whether recalling applies?
ওই তো অন্য
Like yes,
জাজমেন্ট,
sir.
অন্য জাজমেন্টটা সেই জন্য দিলাম, ভুরিয়াস ফেম।
ঠিক আছে।
এখানে বলছে, my lord, this other judgment has given, my lord, 1999 4 SCC records that recalling is allowed when fraud is committed. Paragraph 6, my lord will see.
Yes, you have placed the judge.
I have placed that, my lord. Now, my lord, who has played the whether is amounts to fraud or not, that also, my lord, I have placed before your lordship, my lord. That suppression of material facts to gain advantage on your other side. Tantamounts to fraud. Who has gained advantage of the fact that state has preferred an appeal?
Okay, very good.
I'm grateful, my lord.
Hard. Please take down. আস্তে আস্তে নেবেন, হ্যাঁ? যদি শুভ judgment আমরা রাখবে। হেডিং করুন সিপিএন আর সিপিএন নাম্বারটা দেবেন দুটো ক্যান 1 of 2025. Common order. Right. Okay. Instant application for recalling was preferred by the state respondent regarding recalling of an order dated 10th of December 2024 passed by this court. Full stop. The application for recalling was preferred when the petitioner has filed an application for contempt for alleged deliberate.
As on date, my lord, the contempt is not served officially, my lord. My lord, kindly not record that contempt.
The
There's no
contempt is there. You file at the time of contempt. That is the record.
no, contempt is not served, my lord. As on
Contempt
date,
is coming with the record. That is the list.
it is in the
says
list.
contempt.
It is in the list.
There. List is there. We cannot deny. Not served. I'll take up. Not served. Contempt for alleged deliberate violation of direction of this court. PD order dated 10th of December 2024. Full stop. Facts suggest that the application for contempt was not served upon the alleged contemptor stroke state respondent. Full stop. Mr. Chatterjee, learned counsel, appearing on behalf of the respondent authority, stroke petitioner, within bracket can 1 of 2025 bracket close, submits that the impugned order dated December 10th, 2024 was passed by this court by suppression of a fact, by suppression of a material fact. He submits that this court has passed the order by the strength of a order of coordinate bench of this court in WPA 2836 of 2021, where clause 7 of impugned notification was declared at ultra vires. Full stop. It is the firm contention of Mr. Chatterjee that the state has preferred an appeal against the order passed by a coordinate bench of this court in WPA 2836 of 2021. Full stop. 2836 of 20. He submits that appeal is still pending and yet to be disposed of. The same fact and yet to be disposed of. He submits that petitioner was well aware about the fact but has not disclosed before this court regarding the pendency of the appeal. Full stop. Mr. Chatterjee has also relied upon a specific paragraph of the impugned order of this court, wherefrom it appears that this court has come to an opinion that as no appeal has been preferred by the state, thus the direction of the coordinate bench regarding declaring clause 7 of impugned notification to be ultra vires attained its finality. Full stop. He submits that the petitioner purposefully and with a specific reason to have an order, have a favorable order, suppress the material facts. He submits that the act and action of the petitioner tantamounts to fraud. The impugned order dated December 10th, 2024 is required to be recalled on that ground. In support of his contention, he cited two decisions of the Honorable Apex Court reported in Budhia Swine, SWAIN, and others versus Gopinath Dev and others, reported in within bracket 1999 for SCC 396 and G Veda VEDA versus M Manoharan Jitham GITHAM Jitham, reported in 2016 SCC Online MAD Madras MAD 33792. Next paragraph. Mr. Ramanand Agarwal, London Senior Counsel, appearing on behalf of the petitioner, submits that instant application for recalling is not maintainable in the eye of law. He submits that the usually recalling application is maintainable when one party was not heard. He submits that from the impugned judgment dated 10th of December 2024, it would be revealed that the state respondent was properly represented. He further submits that this court, before passing the impugned order, has given sufficient opportunity to the learned state advocate to take appropriate instruction whether any appeal is pending or not.
Why don't I have friend that?
No, not necessary. Your submission is sufficient. That is not. Full stop. The in spite of such opportunity was given by the state respondent has not disclosed regarding the factum of pendency of the appeal. Full stop. This further submits that the petitioner has not suppressed the fact, but it is the state authority who himself preferred the appeal but does not disclose the fact before this court instead of giving sufficient opportunity. Full stop. In support of his contention, he cited his contention. He cited decisions of Honorable Apex Court as follows. Korun, Asit Kumar Kaur versus State of West Bengal. Within bracket 2009, 2 SCC 703. Next, Comptroller and Auditor General of India versus K.A. Jagannathan and another. Within bracket 1986, 2 SCC 679. Mr. Agarwal further submits that when a law has been declared by a competent court regarding declaring one provision to be ultra vires, even if the appeal is pending, the declaration of the competent court regarding declaring a statute to be ultra vires does not affect or said to be a declared law, said to be any declaration of law. In support of his contention, he cited a decision of Honorable cited a decision of this court reported in within bracket court Piyush Kanti Chaudhary, reported in Piyush Kanti Chaudhary versus State of West Bengal, reported in within bracket 2007, 3 CHN 178. Full stop. Mr. Agarwal next para also argued that the Honorable Supreme Court in Dr. H. Punidhera Singh and others versus K.K. Sethi, reported in 1998 within bracket 8 SCC 640, has observed that if a contempt application is pending and at the same time appeal is also pending, the contempt application has to be heard first, has to be heard and disposed of first. Full stop. Having heard the learned counsel for the parties, also considering the observation of Honorable Apex Court regarding merit of the application being Can 1 of 2025, it appears to me that this is an application for recalling of an order passed by this court on 10th of December 2024, for alleged violation of the direction of that order. The contempt application is pending. Full stop. At this stage, the instant application is preferred by the state authority for recalling the order. In Budhia Swine, the Honorable Apex Court at paragraph 6 has observed that paragraph 6 ta refer court. Paragraph 6. Paragraph 6. In G. Veda, next paragraph. Honorable Single Judge of a Madras High Court, while dealing with the suppression of fact before a court and how it tantamounts to fraud, has referred several judgments of Honorable Apex Court and has observed that and has observed that it is now well settled principle within inverted comma the court. It is now well settled principle that fraud vitiates all solemn acts, full stop. If an order is obtained by reason of commission of fraud, comma, even the principle of natural justice are not required to be complied with for setting aside the same. He also pointed out the honorable division. He also pointed out the observation of Honorable Apex Court in Union of India versus Ramesh Gandhi, wherein the Apex Court has observed that non-disclosure of non-disclosure of all the necessary facts tantamounts to playing fraud on the court. Full stop. Inverted comma close. Next part, and again within inverted comma, if he withholds a vital document in order to gain advantage on the other side, then he would be guilty of playing fraud on the court as well as on the opposite party. Full stop. In Ashit Kumar Kaur Supra, Honorable Supreme Court has dealt with the merit of a recalling application in paragraph 6. Paragraph 6 টা set out করা। ছোট আছে। In Comptroller and Auditor General Supra, Honorable Supreme Court, in paragraph 20, has observed the discretionary power of the High Court to issue mandamus as follows. Paragraph 20 to set out code. I have perused the order book, including the orders of this court before passing the order impugned, dated, 10th of February, 10th of December 2024. It appears that state was represented by a learned counsel at the time of hearing of this matter. The fact suggests that at the time of disposal of the matter, none of the parties appearing before this court has disclosed about the pendency of an appeal against an order of this court, on the basis of which against an order of a coordinate bench of this court in writ petition number WPA 2836 of 2021, comma, on the basis of which the impugned order has been passed. Full stop. This court had specifically observed in page 4 of the judgment regarding the effect of declaration by a coordinate bench of this court regarding the impugned clause of the regarding clause 7 of the impugned notification as follows. এইখানটা করবেন এভাবে করবেন I make it clear that করুন I make it clear that থেকে শুরু হবে আমি এখানে মার্ক করে দিলাম I make it clear that থেকে এইটুকু read petitions, several read petitions. Full stop.
My lord, kindly take note of the fact that your lordship has taken note of the fact that state has not filed any appeal. Page 4, my lord, last
Yes,
part. Lordship
I just
taken-
have just noted.
Sorry.
Full stop. So it is true that this court has passed the order on the basis of declaration of the clause 7 of the impugned notification to be ultra vires. Full stop. Let me consider the merit of the recalling application. Full stop. It is the contention of the contention of Mr. Chatterjee that when contention of Mr. Chatterjee by relying the judgment of Budhia Swain that when a court is misled by a party, the court has by a party regarding a fact which prejudice a party, the court has the inherent power to recall and set aside the order. Full stop. In the present fact, the situation is irrespective of critical to that of the order passed by the court in Budhia, passed by the Honorable Supreme Court in Budhia Swain. In the case of Budhia Swain, the inherent power of the court to recall an order has specifically observed that a party has obtained an order by suppressing a material fact. But in the present case, none of the parties appearing before the court has pointed out that an appeal is pending. Full stop. Let me consider who is the party relevant to disclose the matter that a party appeal is pending. Admittedly, the state respondent is the party who preferred the appeal. Full stop. The state respondent has allowed to use the affidavit in opposition against the writ petition. In the affidavit, they have not disclosed regarding the pendency of the appeal. Moreover, during the course of hearing, several opportunity was given to the state respondent to disclose the fact whether any appeal is pending or not. Instead of that, the state respondent never disclosed the fact that appeal is pending. The state respondent was never disclosed the fact that the appeal is pending. On the basis of submission of the parties, this court passed the order. It appears that the state authority themselves, state authority specifically the learned counsel appearing on behalf of the state authority may not have the sufficient instruction regarding the pendency of the appeal, but the concerned department who use the affidavit by swearing before the competent authority of this court has the duty to disclose the fact. The act and action of the state authority cannot be only said to be non-disclosure of fact, but also when there is a duty to speak, they have kept silence. Now it appears that when the petitioner filed an application for contempt, the state authority suddenly came up with the fact that there is an appeal pending against the order passed by a coronary bench of this court. So truly, the fraud or suppression of fact or vice thereof lies upon the state respondent, not upon the petitioner hearing. Full stop. I make it clear that the state authority have given sufficient opportunity to disclose the fact before the court, but they have not stated before the court that the appeal is pending. The state authority cannot be given opportunity to recall the impugned order on the basis of their own fault. Under the same observation, it appears to me that the observation of Honorable Apex Court in Budhia Swine Supra is not applicable in the present facts and circumstances of this case. Moreover, it appears to me that the
Lord, may I only interrupt for once?
Mr. Chatterjee, I am passing the order.
I'm sorry, Milord, I'm sorry.
Moreover, it appears to me that the Honorable Apex Court in Asit Kumar Kaur, Supra and Comptroller and Auditor General Supra had specifically observed the merit of recalling application in the impugned order dated 10th of December 2024. Both the parties were represented, and after taking the affidavits of the parties, after receiving the affidavit of the parties, this court has passed the order in open court in presence of the parties. Thus, the allegation of practicing fraud, rather allegation of non-presence of any party, cannot be lied here. Under that circumstances, the application for recalling appears to be not at all maintainable in the present facts and circumstances of this case. Moreover, in considering the fact, in considering the brief hint of the merit of this matter, by virtue of decision of by virtue of decision of a division bench of this court reported in Piyush Kanti Chaudhary Supra, it appears that pendency of appeal against an order cannot be said or amounts to any declaration of law, which can bind upon the parties. Under the above observation, I find no justification to allow the application being Can 1 of 2024. Accordingly, the application being Can 1 of 2024 is considered and dismissed.
Okay.
Let the contempt application be appear in the list.
My lord, let the direction for service of the
Okay. No, let me hear the contempt first. 22nd.
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 Right. Yep. Similar order in item number 7, my lord.
Yes.
Deeply obliged.
We are very grateful for such patient hearing, my lord.
No, no.
Very grateful.
That is
Thank you.
always there.
Thank you.
That is always there.
Thank you.
Deeply obliged.
Yes. Next. কেন আপনি বের করছেন কিসের কন্টেম্প্ট এটা গ্রুপ 8 এর গ্রুপ 1 এর লিস্টে আছে তো রাখলেন তাহলে কি হয়েছে লিস্টে WPA contempt application হিসেবে আছে
Well, we have filed a contempt application. It was not appearing in the daily list. So, Milord, a supplementary list, Milord, was published.
very well so what is the matter
Milord, if your lordship, Milord,
so
kindly,
this is contempt application
yes. Now, Milord, if your lordship, Milord, kindly takes up page 20 of the contempt application, Milord.
yes
Here, Milord, the order starts. Now, Milord, the actual portion is at page 22.
yes
Milord, since the physical verification would close the issue, so raised in the instant writ petition, this court does not find any justification in taking a descending view to what has been taken by the coordinate bench in the said writ petition. Accordingly, this court directs the state of West Bengal through its appropriate agency to cause a joint inspection of the site in question along with the representative of the petitioner and the report shall be filed by the respondent number 4 in the form of an affidavit stating the outcome of the said joint inspection and the report submitted by the inspecting authority. Now, my lord, they have not done this. My lord, what happened, my lord, after this order was passed, my lord, the state of West Bengal preferred an appeal. Now, my lord, the appeal was pending, my lord, since, my lord, 2018. Now, my lord, the matter was heard out and thereafter the appeal has been disposed of, my lord, by the Honorable Division Bench in this year, my lord, 2025. My lord, the order, my lord, is at page, my lord, 25 of the petition, my lord. My lord, here, my lord, the order starts, my lord. Your lordship will find the date January 21, 2025. And my lord, my lord, if your lordship, my lord, kindly takes up, my lord, page 28, the appeal being FMS so and the connected application are dismissed.
no interference is called
No interference. Now, my lord, we have requested them, my lord, by way of a letter, my lord. The letter is appearing at page 29 to cause an inspection, my lord, in terms of the order of the Honorable Single Bench.
where is the
It is
where
at
is the letter
my lord, page 29, my lord. It starts. Now, my lord, my request is at page. My lord, I have intimated them, my lord, if your lordship kindly takes up page 32, my lord, last paragraph. I have categorically stated, my lord, at page 33, my lord, what are the steps to be taken. They have not taken any step.
okay hard please take down this contempt application is taken up as a supplementary daily list. Full stop. Or the learned counsel for the petitioner. This is an application for contempt of court act. This is an application for contempt of application under contempt of court act. Read with Article 215 of the Constitution of India against an order dated for deliberate non-compliance of an order dated 23rd of August 2018 passed by a coordinate bench of this court in WP 14482W of 2018, which was affirmed by the Honorable Division Bench in, what is the number?
My lord, it is at page, my lord, FMA 802 of 2020.
FMA 802 of 2020, dated 21st of January 2025. Full stop. Heard the learned, having heard the learned counsel, also perusing the impugned orders annexed with the contempt application, it appears that there are sufficient reason to proceed with the contempt application. Accordingly, petitioner is directed to serve the application upon the alleged contemner and file an affidavit of service on the returnable date. Let the matter appear in the list on thirtieth April.
My lord, 30th, my lord, my learned junior is having a problem. If your lordship kindly takes up on 25th,
No, 25th cannot be.
my lord, then my lord, 28th,
28, 29, I have group 8 matters.
30th, my lord, then 30.
30.
Grateful.
Next,
Madam, for the private forum.
I am for the petitioner. This is a read application.
what is the application?
Yes, I'm.
My lord,
This is a read application.
Can application and copy file?
This
An
is
application.
appearing under the heading of application.
Application.
Yes.
Can 1 is running in the list. Can 1 of 2024, what is the application?
This is the application. This is the copy. Actually stated here. The copies are. My lord, these Honorable Justice Boshak Bhide order dated.
Give me the
Third-
can 1. Where is can 1? ছেড়ে রেখে দেন কেন can? আমি এতে দিয়েছি না, খুলে দেন। Yes,
This is an application.
National Highway. I mean,
On-
Lordship, Miss Manika Roy is appearing for National Highway Lordship,
appearing for,
National Highway Authority.
okay.
Her father got admitted in the hospital, so kindly make it not today, Lordship, please.
No, ঠিক আছে তুমি দাঁড়াও. My lord, this is the matter. This is regarding illegal encroachment of the government land in front of my property, thereby causing impediment to my ingress and ingress from my property. My lord, this
What is the
matter
writ
was
about? What is the writ about? What is the writ?
read. My lord, kindly come to kindly take up this CAN application. Kindly come to page 9. My lord, this is the order. It is the wherefrom it will be clear that this is an illegal encroachment of the government land in front of the petitioner's property, thereby causing impediment to the egress and ingress from my property. Honorable Justice Boshak Bhide order dated 30th July 2019 called for a report from National Highway Authority. They filed a report wherefrom they have observed that illegal encroachment was there, but that land is PWD land in front of my property, not their land. There was an observation that we have another gate wherefrom we are going out from my property, but that is not correct. So in view thereof, this CAN application has been filed and annexing the photographs of my property. That is kindly come to page 17, my lord.
No, you made a prayer in the writ petition for removal of illegal constructions.
Yes,
Who made the illegal construction? State authority.
that is the private respondent, my lord.
Private respondent made the construction.
Yes. This Bijoy Agarwala.
So why should I direct the respondent authority 2 to 4 to remove the illegal construction instead
Because
of
it is
5?
no illegal. That is on the land of the government land. So that's why the government authority should be directed. Previously, this NH highway has demolished a part of that property of the private respondent. My lord.
So your prayer is for illegal removal of illegal construction
Construction in front of my property
in the writ petition as well as in the application.
in the application also.
So the same prayer is there.
No,
It can be
it
taken
is,
up
it is
together.
not, it is not that. It is that what the in the CAN application, I have challenged the report of this NH Highway Authority to the extent that I have another access where from I am going, so I am not being affected by this illegal construction.
And your prayer is that the respondent must be
Yes,
directed
because
to
unless and
demolish
until
the illegal
it is on
construction.
PWD, it is that is in the writ petition. I have not prayed for over the PWD any direction, but however, after the filing of the report of the NH National Highway Authority,
You did not
I
challenge the
came.
report. You did not challenge the report in your
Yes.
CAN application. Now you see the
Yes,
prayer.
yes, kindly,
You see the prayer.
kindly come to page paragraph 5 at page 5 of my CAN.
I understand you have contended that the report is not correct, but your
Huh.
prayer is not there regarding
Prayer is no. Considering that I have asked for this my final
CAN
writ.
application can be heard along with the writ petition.
Yes,
This is the matter.
yes.
That can be heard along the writ petition. I'm fixing the date for hearing.
And
In the meantime, if they
one thing, my lord, may I submit before lordship?
Yes.
What is the scope of the writ application? Subject to question, my lord, what is the scope of the writ application? That there is a national highway. Encroachment was made in the national highway. There is 3 provisions are there. My lord knows better than us, my lord. So for the
I do not know. You just disclose. This is the first time I am hearing the group.
there is
one
a
that-
from the purpose of the national highway. There's
Yes.
specific provision for maintenance and guidance of national highway. The national highway authority is the authority for removal of encroachment. If it is a government land, then West Bengal government another documents actually apply. And so what is the state highways? Bengal Highways Act will apply.
Yes.
So these are the 3 premises on the basis of which the encroachment can be removed. Now, one can consider what are the pleadings made in the writ application. Primary pleadings made is that the paragraph 4, this is the specific pleadings that the private respondent may encroach the national highway. So a prayer was made for the purpose of national highway to be directed to take steps for removal of the same. National highway, after coming into findings that no, national highway has not been encroached, might be some encroachments where the PWD land is concerned. Now it is converted, subject to question, if I am not wrong, this is the sum and substance of the report. Now he wants to convert this writ application another competent land under this.
Include one prayer against the respondent number 6.
Yes. Now, my lord, now the entire gamut of the writ application has been changed to something else. Now, my lord, the provision has been mentioned in the statute itself that only the magistrate and the magistrate is the authority for the purpose of initiation of any proceedings. So I put this question to myself: as on this day, what are the documents are pleaded is before your lordship for the purpose of passing that out? I am putting this question to myself: whether the pleadings can be, my lord knows Mahinda Singh's judgment, whether it is there, whether it is subsequently, my lord.
Okay. So that I know. Now issue is that. So what is the matter of pleadings in this matter?
Kindly come to page 6, para 8. Page 6, para 8, my lord.
In the
Of the
writ
writ petition.
Read
Yes.
in the read whether pleadings complete.
No, pleadings has not been completed. Writ application form.
Pleadings has not
No.
Not yet been completed.
That the petition states that the respondent number 5 has constructed Paka 2-story building,
Yes.
shop room upon the land of the National Highway Authority. Paragraph 4, page 4. In the writ application.
Yes.
Illegal unauthorized construction, the petitioner is facing great difficulties of highways from petitioner's land, as the said national highway is the only road to ingress and egress from his family members. So I'll satisfy your lordship, this amendment cannot be go in the national highways. The national highways opening is strictly in terms of the National Highways Act.
Yes.
Nobody can get access from anywhere from he wants to go to the national highway. He might have a house beside the national highway, but his entry cannot be as his own choice. So this is the premises on the basis of this writ application has been filed. Now I can consider the report once. Page 3, report, paragraph 3.
Where is the report?
Report filed by the respondent number 3, date 14th, file November 2019 by the National Highway Authority.
Report. Yes.
Page 3, paragraph 3, last paragraph. On spot evidence, it appears no portion of the plot of land such as has been acquired afresh. In this course of the going process of acquisition land widening such and such, however, it has been observed that some portion of PW land are being occupied by respondent 5. So this was the premises on the basis the report was filed. So, and now I'll come to page 6.
Yes.
Page 6, my lord. Second paragraph, on spot verification, my lord, got it. Appears no portion of areas has been acquired afresh in the course of ongoing process of acquisition, waiting for, but some portion of the PWD land previously acquired are being occupied by 5. It is on the northeastern side of the public road beside the National Highway Authority. So the premises on the basis of the writ application has been filed, now has been changed under the new act. So this was the premises on the basis of writ application was filed. Cause of action for filing of the writ application, whether can be altered on the basis of the subsequent report without.
My lord,
Let him file an amendment application. We can consider the same.
here we had no knowledge about this land under whose occupation
The report has placed before this
after
court.
that we have,
seen
that's why we have preferred this CAN application.
Can application can be whether can application can you amend the
Gamut of the
Prayers,
petition cannot be
entirely cannot be
My
changed.
lord, let there be, I am praying for a leave to file my amendment application for.
amendment of the entire petition. It will change the entire.
So,
that
file
is
a
all
fresh-
choose. That he can choose.
You can file a fresh or you can
If
file
I
an
can-
application
I-
for amendment.
I will file an application for amendment also.
Amendment file. Then, my lord,
So what will be the fate of can application? It would be heard along with the,
Along with
yes, amendment.
okay. Please take down. Upon hearing parties, it appears that the merit of the merit of application being can 1 of 2024 cannot be decided without hearing the merit of the instant writ petition. At this juncture, the petitioner seeks leaves to file an necessary application regarding amendment of the pleadings. On considering regarding amendment of pleadings. On considering the submission of the petitioner, let the petitioner be at leave to file the amendment within 3 weeks from date.
An objection if
The application for amendment has to be served in advance to the learned counsel for the respondents. Full stop. The respondent authorities is at leave to file opposition, if any, against such application within 2 weeks thereafter. Let the matter appear in the list on 15th of May 2025.
the private respondent also, my lord, was granting leave to the respondent authorities. I am the private respondent.
Okay, respondent
And
authorities
also-
and private respondent.
Yes, my lord. Otherwise, my lord,
Okay, okay.
grateful to your lordship.
Thank you. Next.
that I appear on the petition of that. The this matter relates to that your lordship knows there is an act called Petroleum Minerals Pipelines Act, in short PNMP Act 1962, which gives power to the authorities to acquire land only for a limited purpose, not of for not building the pipelines for smooth supply to different areas, oil pipeline. These are underground. Not absolute, it is not absolute acquisition of the land, ownership is not vested. Only the right of use below the ground to lay the pipeline. And the Act also says, and the Supreme Court also recognizes the right of the owner to use the agriculture, to use the land for which it was being used before the notification. If it is agricultural land and he was cultivating the land, he can cultivate the land over the land. This is not well settled principle of law. Now here, without last occasion, my learned friend was directed to furnish to take instruction whether the adequate compensation has been paid. My prayers are twofold: the compensation as per law to be paid to me. There is no dispute that I am the land user. My land has been acquired for that purpose. And secondly, I may be allowed to cultivate the land as per the section 9 of the Act and as per the Supreme Court judgment. My learned will not dispute I am the recorded owner. That is also there at page 16 to 27 of the writ petition. The record of rights are not annexed. And your lordship need not trouble, there is no dispute. Just one document I'll show that I am the land user, page 116. That will suffice.
There must have a certificate.
Yes, that's land user certificate, 116. So without wasting your lordship's time, straightway 116, that shows that I am Amores Jana, I am the writ petitioner, and my land has been acquired. I am the land user certificate. This is not admitted fact. Now, straightway, kindly takes just one judgment. This is the quoting the judgment, quoting the law. Kindly comes to paragraph 21. This is 2016 9 SCC 791.
Paragraph 21.
21 at 811. Section 7 stipulates, has your lordship got it?
Yes.
Section 7 stipulates that no pipeline be laid under any land which immediately before the date of notification under section 3(1) was used for residential purpose, or any land on which there is permanent structure in existence, or any land which is appertinent to a dwelling house. It is clear that only such lands are to be considered for acquisition of right of user therein, which are either lying fallow or are being put to agricultural use. It is obvious that care is taken to cause least possible damage to the holdings of the landowners concerned. According to section 9, after the pipelines are laid, the owner occupier could use the land for the purpose for which it was being used before notification under section 3(1) was issued. Section 9 certainly imposes some restrictions in the sense that such owner occupier cannot thereafter construct any building or any other structure, or construct or excavate any lake, reservoir, or dam, or plant any tree on such land. Barring such restrictions, the owner occupier is within his rights to use the land for the same purpose for which the land was being earlier used. But this is my submission. My prayer are twofold in the prayer portion. Firstly, the adequate compensation, which they should take instruction and tell before your lordship whether I was paid. And secondly, right to cultivate the land. And third prayer is also there for residential, to construct residential, that I cannot do as per law. That kindly comes to the prayer. Prayer A is the compensation and allow me to cultivate the land. Construct residential house, which I cannot do as per law. Now, this prayer I am not pressing. Construct residential house if necessary. That I cannot do as per law. So this is my simple prayer.
So compensation and the right
And
of cultivation.
And another prayer was there for appointment, that may be considered, but last occasion there is a hurdle in the landed code. Earlier, Justice Kapoor recorded that my prayer is limited to that, but in fact that prayer is also there. Earlier they used to give appointment to the affected persons.
No, that is
But be
all
that as
a
it may.
separate issue, or
Yes.
not in the issue
Right.
of this matter.
No, their prayer was also there, but I am not But that prayer is also there at paragraph D.
No,
Prayer
now
D.
you are pressing the prayer of
Compensation and-
compensation
And right to use the culprit.
whether the authority has used affidavits in this matter
No.
On 20th
or report.
on 20th of June 2024, there was a direction to file a supplementary affidavit, my lord. May I file it a copy of the
I'll then file the exception to the report.
Copy of the
নিচ্ছে, নিচ্ছে।
দুটো ভলিউম আছে।
মানে কি দুটো সেট?
না, দুটো ভলিউম আছে।
দুটো ভলিউম? এই সামান্য কারণে দুটো volume?
অনেকটা জায়গা আছে।
All instructions so many voluminous documents.
My lord, my instruction is that, my lord, all the other co-owners of this plot of land has accepted the compensation, but the petitioner has refused to accept. His amount is lying with the authority. He can go and collect it. He has specifically refused to collect it. That is why it's pending with us. And as far as the second prayer is concerned, whether it is he has been allowed
Allowed him to cultivate.
My lord, may I take instruction whether the work of laying down of the pipeline is completed or not? Once it is completed, it is definitely the owners will get the possession of the plot and
You have not stated anything in this supplementary regarding that,
regarding
regarding the use of land,
regarding whether
the
the
status of the
yes
lying of
status it is not the matter regarding payment of compensation and all the notifications, because earlier when the matter was being heard, it was argued that the land has been acquired without any notification. That was the argument earlier.
I was not, I was.
না না আগে কোচিংটা করছো
No, 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 not in that.
Not
matter.
like that.
Not
We
in
are-
this matter.
So we have annexed all the notifications.
That's why it is so
Yes, that is why,
Oh.
and all the documents that
That's why so healthy.
No, no, it is not.
and
my lord.
is
It is not that matter.
Very.
in the petitioner also raised objection. His objections were or have been considered. All those things are all I've brought on record. Let me take instruction whether the work is completed or not. Once the work is completed, the petitioner will definitely get back the land and he can cultivate or whatever.
My client's instructions are they are not allowing me to enter into the land even. That is the instruction. Let them take the instruction.
They are constructing the
If
pipeline,
this,
so
my case
they
is
should not
completed.
allow anyone.
It is completed.
Once it is completed, it will be given. Whether it is
Take the
completed.
instruction and stay
No,
before the court.
What about the point they have raised in the supplementary that you have not taken the
I'll
compensation?
consider, I'll take instruction and
So whether
file
you
the report.
want to use any
Yes,
reply to that or?
Yes, yes, definitely.
We'll fight.
We'll file. We'll file the exception.
Please get down.
And one more thing, that the prayer for appointment was also there.
I'll
I'll also-
consider at the time of disposing of that matter, not
Yes,
now.
I'll also deal with.
Now you use the affidavit or reply anything?
দাঁড়ান next second. তা ঠিকই আছে, তো আগে তো আছে ছিল, সেই রিপোর্টটা ছিল।
Please take down.
But that was order is also there on 28th June. I'll file the exception. That order is also there. And the point
In
of
terms of direction, in pursuant to the direction of this court on June 28th, 2024. The respondent authority place supplementary affidavit in 2 volumes. Let the supplementary affidavit be taken on record. Copy of those volumes were served upon the learned counsel for the petitioner now and here. Full stop. The petitioner is at leave to file exception, reply, if any, against the supplementary, against the affidavit within
3 weeks. 3 weeks.
within 3 weeks. Let the matter appear in the list on May 8. May 8.
May
3
8.
weeks means May 8.
Just one observation. All points are left open, but I'll urge all the points.
I have not
No,
heard
no, not
anything.
that, but
I have not
since-
passed anything.
Since I am also taken the point of appointment.
Let
that
it
is-
be open there. You have made a prayer in the writ petition. I will deal with that.
But
I will deal with that.
coordinate bench observed.
that
we
point
are
was
not-
If there is an observation, that it
Observation,
should be binding upon everyone.
I'll file the recalling application later.
No. It is binding upon
What is
everyone.
No, it's just interim or stage, at interim stage. At interim stage.
I have not heard anything. Okay.
Mother,
I have not heard anything.
order.
Next.
8th May.
In that matter, I am appearing on behalf of the petitioner. Pursuant to the order dated 9th July 2024, the learned government leader did not serve any legible copy till date, my lord. Kindly see the
Attempts were made, he refused. I am carrying the legible copy since then. I'm handing over to him, my lord, before your lordship. Let him check whether it is legible or not.
Okay, you check it.
It's a
Then I will
case
pass the
of
order.
1981, my lord. Copies
That's
are
why
black,
the illegibility is.
my lord. But it is ready. It can be read, my lord. Let him, let my learned senior check and satisfy himself, my lord, because it's very contentious.
My lord, I will file exception to the
First,
status
kindly sir,
report.
check if it is
Yes.
legible or not. It was tried, my lord, once or twice. I should not make submissions about that. It was not accepted.
এটা তো
1999 কোন কোন ফর্মগুলো আছে সিগনেচার এইটুকু আর কিছু লেখা নেই।
না না এখানে ইয়েগুলো আছে
এর থেকে এই কপিটাই আমার কাছে আছে।
যাই থাকুক
দেখুন দেখুন যেটা আছে আমি আপনাকে দেখুন।
one page is not legible, my lord.
But this page, my lord, this is the copy which I have.
Then I can allow you to inspect the record, original record, if you want. Otherwise, some pages are very old. You know that if we make a Xerox or like that in the old copy, that would be like that.
The original copy, my lord.
Original copy. Original copy now required to place before this court for inspection. If you want, I can allow you.
Yes, my lord.
If you want, I can allow you to go to the department and inspect the record.
You know, in Tamluk.
Whatever may be, I do not know what they are.
Chandipur, my lord, Nandigram.
Where they are, I do not know. You can.
No, no, office টা হচ্ছে Tamluk. District office is Tamluk.
I can allow you. That's why.
So
Let's
only
start
one
the
page,
hearing of
apart
this
from
matter.
that,
If you feel some difficulty to read anything of the matter, you just disclose the matter at the time of hearing. If that is show material, I can allow you to go there.
apart from this one
Apart
page, my
from
lord,
that, you can
he
start
can
the
read
hearing.
everything.
Yes,
Okay.
Yes, ma'am.
Very well. Please take down. Mr. Ritesh Kumar Ganguly, learned counsel appearing on behalf of the state. Okay.
I'm not Mr. Ganguly, my
Okay,
lord.
you are not Ganguly.
Mr. Bandyopadhyay is engaged in this matter,
Okay,
my lord.
okay.
It's an old matter. Mr. Orko Nag was engaged on with him, my lord.
So
He is
Mr.
no-
Ritesh Ganguly name is there.
Earlier, my lord,
Okay, okay, very well. Learned counsel appearing on behalf of the state authority handed over a legible copy within brackets so far, bracket close, to the learned counsel for the petitioner in terms of the direction of this court on 9th of September to 9th of July 2020. Full stop. Learned counsel for the petitioner find some difficulty in reading out some portion of the
one page, my lord.
report
Only one page.
in bracket, one page of the report. Full stop. If the said illegible page is really required for determination of this matter, or place the or so required to determine or না কি বলেছি ভুলে গেছি। illegible page, the same shall be considered. The same shall be considered, and the petitioner will be allowed to inspect the original record at the relevant point of time. Full stop. Let the petitioner is at liberty to file exception against the report within 2 weeks.
3 weeks, my lord.
Within 3 weeks. List the matter on 8th of May.
8th of May.
Under the heading hearing, Next.
Grateful, Miller.
Dictate upon the petitioner.
And I am for the respondent.
12, 13 and 14, similar law point, your lordship, same matters. This is the second round of litigation, your lordship, in the similar matter, your lordship. If your lordship kindly takes a page.
It is appearing under the heading of motion.
এখনো তোমার নাম দেবে
Okay,
না?
only motion, no pleadings are there.
No, your lordship.
Okay, what is the matter about?
Your lordship, the land has been acquired by the National Highway Authority for the development of the National Highway Road, your lordship. Now, what happened initially was that as per the act, your lordship, now as its acquisition is being done after 1st January 2015, so the 2013 act is applicable. So they have given me notice for that, your lordship. That notice doesn't describe anything, what was the quantum of amount, how the calculation has been done, and why, under what authority they have paid me the category. So initially, as per the law, your lordship, and the National Highway Act, section 3G1 defines that they should be given award. If I'm dissatisfied with the quantum, then I can go for arbitration under section 3G5. That's the provision. So first they have to satisfy me with the 3G1 award copy, which they have not given. This is the second round of litigation. First round.
Receive the award.
No, yes. The award is under protest. I have not, the amount which they have said, I have not accepted the amount.
You accept the amount on protest.
Yes. No, I have not taken the amount.
Okay, you have not taken.
Not accepted the amount. That is on record as well. They have supplied for that. Initially, what happened, once this is a second round of litigation, on the first round, the court has categorically stated them to provide me with the 3G1. And I have made an application before the competent authority that was supposed to be heard. The order is also there. In the order, it's an admitted position that they don't have an award. There were 5 matters, your lordship. In another 2 matters, the coordinate bench has already passed an order, because if the award has to be passed, it has to have the contents of section 3G7. 3G7 puts down what are the materials which has to be there in an award. Under the new act, section 30 defines that as well, that it has to be an individual award where I'm supposed to get amount. And this composition, the land which has been acquired is an heart. It's a commercial in nature. So the shifting cost, my business losses, everything has to be taken care. So that has been taken. So in that similar other 2 matters, your lordship, where the court has said that you have not calculated as per section 3G1. So to contain the fresh 3G1 and pass an award under section 3G1 and give it handed to the petitioner. That was the order in the last 2 writ petition. So I'm before your lordship. If your lordship kindly comes to the order.
What is your prayer in this writ petition?
Your lordship, I want
Similar prayer.
Similar prayer, because it's an admitted position, lordship, that they have to give me section 3G1. This is the order of the coordinate bench, your lordship. If your lordship kindly see page 64, that's the order of the coordinate bench in the first round of litigation, your lordship. Page 64 of the writ petition. Order dated 16/2/2022.
In which matter?
In the writ petition, part of the writ petition, lordship. It's
So the petitioner has first time appeared before this court by this writ petition.
no, this is the second round of litigation.
Second.
The first writ petition order is annexed at page 64.
That's why this is the first writ petition.
Yes, that's the first writ petition. This is the second writ petition. In the first writ petition, there was a direction upon the authority concerned, the competent authority, to dispose of the writ petition and also supply the 3G1 copy, the award copy.
Respondent number 7 was directed.
Yes, your lordship. He is the competent
Dispose of
authority.
the representation, submit the petition over the period of 2 weeks. Offering reason opportunity to hearing on the party. Very well. So what happened thereafter? Whether they have supplied you the copies?
No, your lordship. The page 67 is the order they have supplied, but that is not a 3G1 award, your lordship.
They have given me a hearing, your lordship. They have called me for a hearing. They have recorded my submission.
So where is the operative portion of the order?
Your lordship, it starts at page.
Start at page 67.
Page 67 it starts, your lordship.
72 is the last of.
There is no provision for giving opportunity of being heard.
If your lordship kindly see page 71, the first paragraph. It says, going through the entire case record lying in the office, it reveals that an area of 0.668 acre out of total area, plot number 356, that's my plot number, your lordship. Jail number has been acquired for widening of NH32 in the district Purulia, while such as a case number. The award for company already been prepared, but due to some hindrance occurred on the said plot of land, post award prepared as per approval of the concerned authority of law according to compensation disbursed. So there is no whisper about the copy of that.
Yes. So
they have not technically given me an award copy, which is they're supposed to give. So
you
what
have
I
not received any copy of the award?
No, your lordship.
My lord, in this matter, my lord, 12 to 14 is the same matter, my lord.
12, 13,
Item
14.
number
13 and 14.
Three are the similar matter.
12, 13 and 14.
12, 13 and 14.
Okay.
My lord, in this matter, my lord, similar matter, my lord, PBS, my lord, coordinate bench, my lord, passed an order. To the effect,
Yeah, I have handed over the order.
now, my lord,
My
lord, that order was passed, my lord, that it will be, if your lordship will see this, my lord, that is his claim is, my lord, that is the 3G1.
3G1.
According to provision of the my lord, National Highway
National
Act,
Highway.
1956 Act, my lord, first, my lord, compensation will be made by, in the process of 3G1. In compensation, my lord, in calculating that 3G1, my lord, there is a provision of 3G7. How to calculate?
Yes.
Now, my lord, my learned friend, my lord, previously in two cases, that was disposed of. One of I was appeared, my lord, and my lord, my lord, Mr. Justice
Ghosh.
My lord, Ghosh, my lord, was pleased to pass this order, my lord.
Direct the respondent number
Direct
7
the
to
respondent 7 to, my lord, consider
dispose of the representation
by
and
giving
giving the copy.
Yes, my lord. As per 3G's calculation will be made as per 3G7 of the, my lord, your lordship can pass that one. If your lordship will not take it otherwise, my lord.
No, by the impugn order, they have not given you any of the
No,
copy.
the impugn order is there. They have
of
not
the-
disclosed the calculation, and that cannot be said as 3G1.
But disclose, my lord, the calculation or other things, my lord. And his claim, my lord, he wants to get that 3G1. 3G1, after that, my lord, 3G5. If
3G?
anybody, my lord, agreed by any order of that, my lord,
National Highway Authority Act at least.
Yes.
Your lordship.
Yes, my lord, I have.
I have this. Your lordship. 3G খুলে দিয়েছে।
if your lordship will 3G1, my lord. 3G subsection 1, my lord.
Yes.
My lord, if any, my lord, that is the first stage, my lord, of that is where any land is acquired under this act, my lord, there shall be paid an amount which shall be determined by an order of the
Competent authority.
Yes, my lord. That is Kala in next, my lord.
Kala, yes.
Yes, my lord. After that, I may not want to go into the merits of the other things, my lord. If your lordship come 3G5, my lord.
3G5.
3G5 is that, my lord, if the amount determined by the competent authority, that is the Kala, under subsection 1 or subsection 2 is not acceptable, but either of the parties means, my lord, he is
Either may be the
body by
petitioner
National
or the
Highway.
competent or the railway
No,
authority.
that is National Highway.
National Highway
And
Authority.
the competent authority of the state is the competent authority, that is the ADM, is the competent authority, but there is two parties. One party is, my lord, that is the
The
petitioner.
land loser
And
and as the NHA. NHA.
National Highway.
Yes.
National Highway. For that reason is not acceptable either of the parties. The amount shall, on an application by either of the parties, be determined by the arbitrator to be appointed by the central government.
By the central government.
Yes, my lord.
Yes.
My lord, he wants that I must get the first, my lord, I must get the 3G1, then I can file the 3G5. Otherwise, my lord, how I can agree by that order? For that reason, my lord, my learned friend wants that I must get that.
And my lord, if your lordship will come 3G6, my lord. Now, my lord, the subject to the provision of this act, the provision of the arbitration and
Conciliation Act.
of 90 shall apply to every arbitration under this act. My lord, if 3G5 is there, then no, there is a restriction clause, my lord. That is statutory restriction, 3G6. You must go to the district court to file taking that chance of arbitration and conciliation.
Section 34, you may proceed to the
Yes,
district court.
section 34.
And my lord, how I calculate the 3G1? That is, my lord, for that reason, my lord, your lordship will see 7.
3G7.
Yes, my lord. The competent authority or the arbitrator, both can determine, while determining the amount under subsection 1
Or subsection 5.
as the case may be, shall take into consideration. Key consideration. What is the consideration? My lord, A, the market value of the land on the date of publication of the notification, that is the publication of notification of 3A. The damage, if any, sustainable by the person interested at the time of taking possession of the land by reason of the slavery of such land from other land.
Yes.
The damage, if any, is sustained by the person interested at the time of taking possession of the land by reason of the acquisition injuriously affecting the other immovable property in any manner or is earned. If in consequence of the acquisition of the land, the person interested is compelled to change his residence of place, business, the reasonable expenses of any, if any, incidental to such change. That is the position of law, my lord. National Highway Act, when we take the land for the cause of the National Highway, my lord, that we must take those things. Here, my lord, my learned friends given that 3G1 I am not getting, and we are not giving him at that time, my lord, that what is the component, all the components was not. So, my lord, he paid for all components 3G1, order of the 3G1 with all components, my lord. And previous order was there, my lord, if your lordship will see. I pray, my lord, in the 3 cases, my lord, your lordship can pass this order and dispose of it.
I am disposing of these matters by directing the authority concerned to again decide the matter.
Yes, my lord.
In terms of 3G7.
3G1.
3G1, following the provisions of 3G7.
3G7. And give him a copy within certain time.
Okay.
And an opportunity of hearing be given, your lord.
Both the parties, my lord, he and National Highway.
Very good.
Yes, my lord, your lordship can pass.
Okay, please take down.
Respondent number 7 is the competent authority, your lord.
হ্যাঁ
এক সেকেন্ড ছোট্ট করে দিয়ে দিচ্ছি।
ওটা হলেই তো হয়ে গেল। বারো, তেরো, চোদ্দ।
তোমাদের না, 12টায় আমি আছি, এটা দিয়ে দিস।
Petitioner's land was acquired by the National Highway Authority. Full stop. The petitioner approached before this court in a writ petition number WPA 1851 of 2022 for necessary direction upon the respondent number 7.
Yes, your lordship, 7. He is the competent authority.
Respondent number 7. Within bracket, the additional district magistrate LA and competent authority of land acquisition Purulia to dispose of the representation of the petition. Full stop. By an order dated 24th of order dated 5th of April 2022. The competent authority has passed the order. Full stop. the petitioner is aggrieved against the order. It is the contention of the learned counsel for the petitioner that the order passed by the competent authority is not in pursuance to the provisions of section 3G, 3 capital G within bracket 1 read with section 3G within bracket 7 of the National Highways Act 1956. Full stop. Learned senior counsel appearing on Mr. Okay, learned Mr. Chandicharan De, learned additional government pleader, appearing on behalf of the respondent number 7, has fairly submitted before this court the impugn order passed by this court has not, in compliance with the provisions of the act, provisions of section 3G within bracket 1 read with section 3G within bracket 7 of the National Highway Authority Act 1956. Full stop. Mr. De has also placed the specific provisions of section 3G within bracket 1 as well as section 3G within bracket 7 of the National Highway Authority Act 1956. Let the said provisions be set out for the proper determination of this matter. For 3G1 and 3G7. Set out. During heard the learned counsels at length. Mr. De, learned counsel appearing learned additional government pleader, has further fairly submits that necessary direction be made to the competent authority to pass a necessary order in terms in following the provisions as laid down herein above. Having heard the learned counsel for the parties, the instant writ petition is disposed of with a direction to the competent authority to pass a reason order in terms of section 3G within bracket 1 read with section 3G, no, section 3G within bracket 1 complying with the provisions of section 3G within bracket 7 of the National Highway Authority Act 1956 within 6 weeks from the date of communication of this order by giving a reasonable opportunity of being heard to the petitioner. Full stop. The petitioner at leave to place necessary documents, if any, at the time of hearing of this matter. Full stop. The learned, the competent authority shall allow all the parties at the time of hearing to demonstrate their matter. Full stop. The concerned authority shall dispose of the matter according to the law and shall communicate the order to the petitioner within 2 weeks from the date of passing of this order. Full stop. I make it clear that this court has not entered into the merit of this matter. The competent authority is at leave to dispose of the matter according to the law without being influenced by any observation of this court. Full stop. Next para. Since no affidavit has been exchanged between the parties, the allegation made in the writ petition shall be deemed to have been not admitted. Writ petition disposed of.
13 and 14, my lord, same order.
12, 13, 14, same order.
Same order.
This book, I am just keeping this book.
Item number 15, my lord, I am paying for note.
Today we have out of time now. Item number
15. Next matter, my lord, I am for the statement. Wait for time.
Okay, very good.
Second approval. Second,
Call the list.
Yes, my lord, before starts, my lord, senior friend. My lord, item number 4, that, lordship, my lord, on the last occasion, it has fallen from your lordship that it will be taken up, my lord. A content matter, my lord, can it be taken up? There are some urgency, my lord.
Very well. Let me take up this matter, thereafter I will take up.
My lord, grateful, my lord, grateful,
You just wait.
grateful, my lord, grateful.
Yes.
May I please lordship, my lord. This,
Have you served?
yes, my lord.
What is the service? Yes, proceed.
My lord, paragraph 2, my lord, I am.
Paragraph?
Paragraph 2.
Yes.
A vacancy notification issued by the subdivisional controller food and supply Siliguri, whereby and where under invited application from individual self-help group or registered cooperative society for filing a vacancy for fair price shops dealership at village Kawakahari under Matigara Gram Panchayat, my lord. Thereafter, my lord, the said notification, paragraph 3, my lord, the said notification eligibility criteria interior required a suitable shop cum godown space with minimum floor space of 400 square feet and covered space of 200 square feet adjacent to the godown for office purpose and to have at least rupees 50,000 as working capital, and applicant must not be convicted in any court of law, implicated in any criminal case, and also to submit the requisite documents as mentioned in the said notification. Paragraph 4, my lord, the petitioner fulfilled all requisite eligibility criteria as such the petitioner on 31st March 2014 duly submitted his application for fair price shop dealership at village Kawahari under Matigara Gram Panchayat block, Matigara district, Darjeeling.
Yes, what happened there? You have
What
applied for
happened,
the
my lord?
license?
Thereafter, my lord, they did not. I have compared all these things, my lord. In spite
Where is
of
your application? Copy of application?
copy of the application, my lord, kindly see page 31. Page 31. Page 31, annexure R4, my lord. Non-allotment, have you found, my lord?
Page 31 is the
Annexure
representation.
4, annexure 4. Yes, I have given the letter, my lord. The
Representation to the authority.
yes, my lord. But my lord, in spite of that, no way, my lord.
No, what happened? You applied for the license?
Yes, yes, everything.
Whether your shop come go down was inspected?
Everything was inspected, everything, my
When
lord.
it was inspected?
That is, I'm giving the annexure.
Where is the copy of inspection?
Yes, my lord, I'm giving. Kindly see, my lord, page 25, annexure P3, my lord.
24, 25. Resubmission of document.
First documents, my lord, annexure R1. P1, my lord. Thereafter, my lord, P3. '25 and 26.
So 25 is the communication from the subdivisional controller asking you to submit a document, to furnish a document regarding showing that you have a bank account of 5 lakh.
Yes, I have.
And also a document to show that you have a godown of size amount minimum 400 square feet.
Everything, my lord, I have.
When you have placed those
my lord,
documents?
kindly see, my lord. Page 27.
No, page 25.
Page 25. Thereafter 26, my lord.
Why 25? Why 25? You have not placed the document?
Yes, everything placed, my lord.
Where is the documents?
That is the, kindly see, this is the documents, my lord.
Then why the memo dated 21st of October 2014?
So, my lord, in spite of that, my lord, there is no vacancies my lord, not fulfilled, my lord. So I
Where is your bank particulars?
well, submission of application with all documents, that is the 31st March 2014. Thereafter, my lord, inspection of shop go down by the respondent number 7, 14/5/2014. Date of issuance of memo number such and such, 10th October 2014. Date of representation of the respondent, that is the 18 to 25, my lord. Everything, my lord.
So where is the document that you have submitted
Yes, my lord.
to have a bank account more than 5 lakh?
My lord, kindly see page 28. That is the chala slip, my lord.
28.
2414, my lord.
DTDC. 28 is the DTDC receipt.
Yes. Thereafter, my lord, kindly see 29.
It is also DTDC receipt,
Yes,
communication.
yes,
No,
everything,
this
my
is not the bank document.
Thereafter, page 30, my lord. Page 30.
This is your 4 lakh, not 5 lakh.
Initially, my lord, 50,000. Initially, in 50,000. Thereafter, my lord, I do not know, my lord, why the 4 lakh, my lord. But
Yes, you have to
my
furnish
submission, my-
document. Whether you have furnished document
Yes, yes.
showing
everything
4,
that is
5 lakh. Where is the document? Show me the document.
my original documents, my lord. My
Let me submit a copy at least. But what document you have placed regarding showing your shop come go down 400 square feet and 200 square feet respectively? Where is the document? No, record shows that one memo was placed to you by the sub-divisional controller on 10th of October. You have not complied with the memo. Again, one letter on 21st of October. So where is your compliance of that memo? In your representation, you have said that you have complied the document, heard the documents. You take instruction and come later on. Okay.
Next, third step.
Next Thursday. Let the matter appear in the list on 17th. Under the same heading. Call item number 4 first.
I appear for the respondents' alleged contenders.
My lord. My lord, direction was given by this honorable court to follow the policy transfer on medical grounds and transfer the petitioner to his home state and to pass a reasoned order considering his representation, which was annexed to the affidavit in reply, and to consider his physical ailments. He has some typical physical ailments. Twice his kidney was operated, and only medical treatment is possible in Medica or Fortis Super Speciality Hospital. And after passing the order of this honorable court, he was being used. Practically, he was being used as ping pong ball, and he was transferred thrice. Last transfer was at Murshidabad Circle, though he resides at Barakpur area. My lord, kindly comes to your lordship's the last order passed by this honorable court on 28th June 2024, and since 28th June he was transferred thrice and mostly in Berhampur area. My lord, kindly comes to page 30. I am reading the relevant pages. So I am reading from third paragraph, page 30. The present petitioner is a bank employee Under Canara Bank, initially he was appointed in February 2001 and thereafter transferred on several occasions. He was posted at the Kolkata Circle Office from 7th day of June 2012 to 25th day of October 2024 and thereafter transferred to Durgapur Circle Office and again posted at the Kolkata Circle Office from 11th day of June 2018 to 23rd day of July 2021. On 1st of July 2021, a transfer order was passed by the respondent authority directing the present petitioner to join Bhubaneswar Regional Office, Bhubaneswar Circle. The alleged transfer order caused some difficulty in the family life of the present petitioner on the ground that he was 51 years of age at the time and suffering from different ailments. Furthermore, his daughter was suffering from acute lung disease and appearing in class 12 final examination. However, one representation was made by the present petitioner on 5th July 2021. He also commented in that representation that due to the prevalent pandemic situation of
No,
COVID-19.
Mr. Chatterjee, I have heard the matter.
Yes,
The
yes,
issue
yes.
I can understand.
Now, my lord, I shall
recollect the matter.
yes, yes,
So the issue
grateful.
is the transfer policy of the bank for the year 2024 has to be strictly followed.
My lord.
The transfer policy said the transfer should be at home station.
And number two, my lord, he needs special medical treatment, which is possible in two special super specialty hospitals, namely Medica and Fortis. He resides at Barakpur area. He is more than 53 years of age. If your lordship kindly comes to page 44, before that, my lord, kindly for my satisfaction, kindly comes to page 33 once. This was the page 33. Your lordship passed this order. Request transfer and SC/ST officers.
Yes.
Second line, request from officers for a transfer to a place of their choice on the grounds of sickness and compassionate grounds may be considered sympathetically on case-to-case basis, subject to availability of vacancies and administrative exigencies. Such request transfers may be considered for 2 occasions in the service as an officer employee. Thereafter, kindly comes to page 34.
So
Page
at the
30
time of passing the order, he was at Bhubaneswar.
Yes.
Thereafter, he transferred to the Bengal.
Yes, transferred to Bengal, but at the remotest area, at Baharampur border area. Firstly, my lord, kindly comes to page 44. Then, kindly comes to page 44. Kindly sees the date. Proceedings of the Assistant General Manager dated 22nd of July 2024. Sri Sanjay Bishwas, Manager, so and so, transferred to from Bhubaneswar. He is hereby transferred to Canara Bank, Umrapur, Berhampur Regional Office. First, he went to Berhampur Regional Office, my lord, remotest part. Thereafter,
Whether they strictly violated the order?
yes, because my lord, your lordship directed to consider his prayer on the ground of physical ailments. If he is transferred to either Baharampur or presently he is transferred to Jahangirpur. Jahangirpur is also Jahangirpur is also, my lord, in Murshidabad district.
Okay.
Those areas are far away, my lord. It is impossible for him at least to survive, my lord. It is unable to stay over there, my lord. Thereafter, my lord, kindly comes to page 45. Within these few months, he was transferred thrice, and on every occasions he was transferred in remotest parts. Kindly comes to then page 45. Kindly page 44, he was transferred on 22nd of July 2024. Page 45 again, within 1 month he was transferred on 31st of August. My lord, Umrapur to Baharampur within 1 month. Thereafter, my lord, again, thereafter page 46.
In the Baharampur, there are good hospitals, I think.
No, my lord, super specialty hospitals are not there, my lord, not there. Thereafter, kindly comes to page 64. Kindly comes to page 64, dated again another transfer on 21st of November 2024 from Berhampur to Jahangirpur. My lord, how many times I shall be transferred from one place to another, but not in a place where from I can get some medical facilities. It is again, my lord, in Murshidabad area, Jahangir,
Whether
November.
it is regular regarding the employees in respect of the employees.
Within 1 month, my lord, not regular. My lord, your lordship can appreciate. I have come before your lordships. Your lordships passed an order, and thereafter, my lord, within 3 months, thrice. This is, my lord, abnormal, my lord. This is deliberate, my lord, and intentional.
Yes.
Before, my lord, I take, my lord, through the affidavit of compliance which I'll be filing. My lord will kindly take page 33 once of my learned friend's application. Page
Yes.
33.
Page 33.
My lord, can you see what the request transfers are? My lord, is that page 33? Request from officers for transfer to a place of their choice on the ground of sickness and compassionate ground may be considered sympathetically on case-to-case basis, subject to
Available vacancies and exigencies.
vacancies and administrative exigencies.
Exigencies.
Now, after this, my lord, after my lord has considered this, my lord will kindly come to page 35, internal page 6 of my lord's.
Yes.
My lord will kindly take from the second paragraph. Considering the entire aspect of the matter, I think it necessary that the case of the present petitioner needs to be considered sympathetically by the bank in terms of the present policy. It appears that representation for request transfer has been made by the present petitioner, which has been reflected at so-and-so page to the reply. Such representation and request has not been lapsed yet. Thus, respondent authority is directed to consider the representation of the petitioner so that transfer policy of the bank for the year 24 may be adhered to strictly. I make it clear that I have not considered other parameters of availability of vacancies and administrative exigencies of the bank, but as the request has been made on behalf of the petitioner and admittedly which was not considered, thus court is constrained to pass a specific order so that the present petitioner may be transferred to his home state, that is West Bengal. Barakpur is not a state. It's a place in West Bengal where he might belong, but it is the home state. Now, my lord, may I file, my lord, my affidavit of compliance at the copy?
Whether you have served this
No,
application?
no, no. Let them
Page
No, no, compliance I have
Compliance,
not.
no, but application.
No, let them serve first the application. They have served.
The compliance I have. Are আমার
Yes,
but
yes.
compliance we didn't get.
You serve the compliance.
Yes.
Compliance I did not get.
Compliance তো দিয়ে দেখো না।
হ্যাঁ, ঠিক আছে, কথাটা fold করে রাখো।
আর একটা কপি নেই? স্যার, ফার্স্ট এখানে ছিল।
No issue, no issue, no issue. Stapler না দিলেও চলবে।
পরে পাবেন। Thank you. My lord will now kindly take my affidavit of compliance.
দিতে যেটা পড়ে দেবো।
My lord will kindly see from my affidavit that he had initially at page number 6. My lord will straight come to page number 6.
Yes.
At the top, B. He had worked in the state of West Bengal, his hometown, home state, Kolkata and the nearby circle offices for a continuous period of 9 years. 2012 June to July 2021. Usually, my lord, officers are transferred. It is a transferable job. Now, then he was transferred in July 2021 to Bhubaneswar, which is outside his home state. He makes a representation immediately on ill health and COVID. My lord, that, my lord, was not favorably considered by us. He makes 2 further representations, my lord, during annual, my lord, we kindly take D, my subclause D. During annual general transfer, petitioner orally requested to consider his transfer request to a place near his home state and requested for Bhadrak regional office. He made that request that he wanted to be transferred to Bhadrak. Now, the competent authority on his request proceeded to Bhadrak on 1st of June 24. So, we acted in terms of his request. Then, my lord, comes this order. My lord's order, where, my lord, we have been asked to transfer him back to the home state, that is West Bengal. So, my lord, in terms of that, we immediately transfer him to Umrapur branch. My lord will kindly come to page 8, subclause F.
Yes.
We transferred him, we considered his representation, we transferred him to Umrapur branch, Berhampur regional, which is home state. Immediately after my lord's order is passed, we transfer him, my lord, and this transfer was effected on 22nd of July 2024. And my lord's order is dated, my lord, 28th of June 24. Thereafter, my lord, he makes a representation that you transfer me back close to my residential house at Barrack. Now, my lord, that is not always possible. There has to be vacancy. I just said this request cannot pick someone and throw him out and place him there. So, my lord, he then makes another, at his request, we consider it, since we cannot transfer him there, we then transfer him to the Umrapur branch, my lord, which is under the Berhampur region. That is, my lord, at H, page 9. My lord, at the bottom of page 9, H.
Yes.
We then transfer him to, my lord, the Berhampur branch. He was at Umrapur in July. From Umrapur, we then bring him to the Berhampur branch, which is a very big branch, my lord, at Berhampur regional office. He is the manager there. Now, what this gentleman does, he says he's a manager holding a responsible post. Every day comes up with a new complaint. I cannot hold keys of the branch. I am sick. I cannot do this. I am sick. I cannot do that. I am sick. So, my lord, I have annexed those letters. If my lord will kindly take those letters, we have annexed those letters of his. My lord will kindly come to page 20. He's, after all, my lord, a manager holding a very responsible post in a bank. My lord is at page 20. I have joined the Berhampur branch on so-and-so, and you have given me charge of holding first set of double lock keys from so-and-so. Since then, I am holding the first set of keys. Here, I would like to state that my health condition is not good, as I have been suffering from so-and-so, so-and-so, so-and-so. I am submitting regular medical bills, and the subject medical bills include hospital bills. Due to the above disease, sometimes I become faint and not have any sense. Further, I wish to inform you that my wife is also suffering. Due to the above reasons, holding first set of keys is not possible. In my 24 years career, I have never refused any work by superior. The branch is having 4 officers. Out of 4 officers, 3 are confirmed officers. In view of the above, I request you kindly to allot the work of holding first set of key to any senior officer. So first he says, I cannot hold key. My lord will kindly turn over to the next page.
No, next page ta next page ta bude nahi na, next page ta nahi na.
21.
21 টা নেই, 20 অবধি আছে। যাকে ঠিক আছে, আমি শুনে নিচ্ছি।
এই খুলে যাচ্ছে তো কিরকম কাগজ আছে? My lord, then he says, my lord, if my lord, a branch manager, my lord, has to go, if I sanction a loan, the duty of a manager is to see, verify with the customer, visit, make pre-sanction visit, my lord, post-sanction visit, see the, my lord, the vulnerability or, my lord, the genuineness of the borrower. My lord, we kindly see paragraph 2. I am suffering from all these diseases. Therefore, I request you with folded hands not to assign any outside branch premises duty like pre-sanction, post-sanction visit, party visit for recovery, unit visit for stock verification. So, as a manager, I will sit in the branch. I will, since I am sick, I will not go anywhere. Now, my lord will kindly come back. I have just shown these letters, my lord, to show, my lord, why we had thereafter had to transfer him back. So, my lord, I have shown at page number 9, my lord, that I had then brought him to the biggest branch at Berhampur, the Berhampur regional office, Berhampur branch under the Berhampur regional office. Then comes these letters, my lord. So, my lord, it's a smaller branch in the same region, my lord, that is the Jahangirpur branch. My lord will kindly take, my lord, page 10. The second paragraph, which has been numbered as B. Since Berhampur branch is the main branch of the region, managers have responsibilities and duties cast on them, which are essential for smooth banking business. In view of the request of the petitioners, my lord, I have shown those letters. Management once again considered the same and transferred the petitioner to Jahangirpur branch under the same regional office. So, my lord, under the same region, I am trying to accommodate him as per his request with less workload. And not just that, my lord, he says he needs multi-speciality hospital. I have disclosed that at page number 11. At the Jahangirpur branch, my lord, there is a multi-speciality hospital, Gangarampur Special Super Speciality Government Hospital, where, my lord, every treatment is available. My lord, I have also, my lord, disclosed in this affidavit that as on date, there is no vacancy in Barrackpur. My lord will kindly take page 11, paragraph E. page 11, paragraph 3. There is only
Yes.
11.
Yes.
There is only one branch of the bank at Barrackpur. The petitioner was previously posted there between 19 and 21 on his promotion as manager. As on date, there is no vacancy in the post of manager at the said branch. So, my lord, I am accommodating him at the home state. That was my lord's order. In due compliance of the solemn order of this court, I have brought him back. At his request, I had then transferred him to whichever branch, my lord, to give him as much possible convenience as possible in the work. But my lord, as a manager, I will not do anything, but I will only be in my hometown. My lord, first of all, my lord, the circulars also do not say that. And as on date, my lord, I cannot transfer him there. There is no vacancy. My lord, this is my compliance. I say I have acted in terms of the order of this honorable tribunal or honorable court. I have brought him back to the state. I have accommodated him at his convenience at a place where he also has access
Very
to
good.
medical.
My lord, shall I add 2 lines, my lord? I am thankful to my to my learned friend that she has supported my version. My lord, she has read from page 35. Before that, page 34, I shall read 2 lines. Page 34, bottom. Respondents, being a statutory authority, has formulated a policy of transfer of its employees. The policy facilitates some particular section of employees who are under old age and are belong to a specific category. The terms and conditions of such policy must be adhered to, not only by the employees themselves, but also to the authority concerned in its true letter and spirit. That was not followed. Then, this line was, my lord, avoided, maybe not intentionally. The bank authority is duty bound to manage the hurdles of administrative requirement and exigencies to fulfill the terms of the transfer policy. This has fallen from your lordships. Thereafter, last paragraphs. Oh, considering the entire aspect of the matter, I think it necessary that the case of the present petitioner need be considered sympathetically, very sympathy. I am asking myself, you are going by technicality, not by sympathy. Sympathetically by the respondent bank in terms of the present transfer policy. It appears that the representation for request transfer has already been made by the present petitioner, which has been reflected at page 20 in the reply on 29th May 2024. Such a representation and request has not yet been lapsed yet. Thus, the respondent authority is directed to consider the representation of the present petitioner dated 29th May 2024, so that the transfer policy of the bank for the year 2024 may be adhered to strictly. Next, I can show that my representation, nowhere I have stated that transfer me to Bhadrok. Nowhere. Dekho representation bar karo kon patay ache? Of my affidavit in reply, I can read. I have never stated that transfer me to Bhadrok. No. My lord, kindly appreciates that
the Bhadrok transfer is everything before the order is passed.
Yes, my lord, yes. Before the order was passed.
After the order was passed, you are the bank manager. You have some duty.
My lord, I have not suppressed, my lord, that my physical condition is not good.
You have to give
My lord,
visit,
my lord, I have not suppressed that
cannot
my
say that I am-
physical condition is not good, my lord.
So what can be done?
My lord, that's why my request was to
So you have
transfer.
to perform as a manager of a bank.
My lord,
So you have some
my
responsibility.
prayer was, all right, in near Barrackpur, there is no vacancy, but can it be, my lord, at a place either near Barrackpur or at Calcutta, so that I can get my hospital facilities. My lord, I have not suppressed. My learned friend read 2 letters. There was no suppression that I have suppressed anything before this honorable court. I have stated, yes, I am dying. And that's why I have sent those 2 letters, that I am unable to hold the responsibility of those keys. This is true, my lord. I am dying. That's why this is my prayer. Your page number 38. Page number 38 of my petition. My lord, kindly appreciates your lordship. It has fallen from your lordship also to handle my representation sympathetically. They are handling technically. They have transferred me in home state, but in remotest part of the state, at Baharampur area, Umrapur, Jahangirpur, within 3 months or 4 months, I was transferred thrice. My lord, I am asking myself, is there any transfer policy wherein a sick person can be transferred on 4 occasions within 4 months? My lord, I have come before your lordships. My lord, kindly pass an order, my lord, so that I can remain not at Barakpur. I am not praying for that, but my lord, at a nearby place, so that I can get my medical facilities. The late, maybe it will be
No,
repetition.
they have made the fact that there is some banks, there are some hospitals having facilities.
My lord, in Baharampur, my lord, I do not know where from she is saying no super specialty hospitals wherein kidney, my lord, kidney, lung, my lord, thrice my kidney was operated. Thrice.
No, you cannot say that I have to post it at the Calcutta.
My lord, at this age, my lord, at this age, I am praying before your lordships under such physical condition that, my lord, I am not praying for to transfer me within Barakpur area, but at a nearby area. I have never prayed that, my lord. I have never prayed that transfer me in Barakpur area, but my lord, in a nearby area. In a nearby area
of the Calcutta.
Either Barakpur or Calcutta, but not at the remotest part, my lord. Anywhere, anywhere. I am not saying that I have you have to transfer me at Calcutta. I am not saying, neither in my representations it has come, my lord. No, I have not stated. And my lord, my representation dated 29th of June 2024, that was not disposed of.
Let them dispose of the representation. I am disposing of the contempt application. If they have not disposed of, directing a specially you dispose of the representation.
And one more, I know there is no rejoinder to rejoinder, but what my learned friend read, my lord, I'll also read the same thing and rely on the same thing. My lord has held, bank authority is duty bound to manage the hurdles of administrative requirement and exigencies to fulfill the terms of transfer policy. Doesn't mean I give it a total go by. And just because I want to be accommodated here, I find it closer to come to High Court from if I stay in Park Street. So please put me in Park Street.
Yes, Mr. Chatterjee, what you want now?
My lord, kindly comes to page 38 of my petition. Page 38.
Your representation?
Yes, my lord. Dated 27th of July. I made representation via my request letter dated so and so to Deputy General Manager HRM Section Bhubaneswar and copy of GM. I have requested to transfer me favorably to a branch section in Kolkata Circle near to my house sympathetically on medical ground considering my present health condition, which is annexed herewith.
It is after the order is passed. No.
Yes, after the order is passed. After the order is passed. Hereafter, they started transferring me on different places. Today, I have received transfer proceeding from the AGM Berhampur.
Okay. Please take down.
My action actually disposes it off. But if he wants it in writing, we'll write it.
Okay. Please take down.
My lord, in the transfer order, it was not stated that my request transfer was considered and disposed of.
Yes.
TADA, both are deducted from me.
Has to be
In case of request transfer, TAD has to be gone.
My lord, but on here, my lord, that was not considered, and TADA. He's being paid. He's being paid. Yes.
Then paid means it was not a request transfer.
Yes. That's why.
Not a request transfer.
Yes, that's why I've come
request
for your
transfer,
lordship.
Your TAD has to be gone.
Yes, that means it was not request transfer.
It is regular transfer by
Yes, my
virtue
lord.
of that order.
Yes, my lord.
Very well. Please take down.
This is our case. ভাইটাল ছিল
Instant contempt application was filed for alleged deliberate violation of the respondent authority for not following the order of this court dated 28th June 2024. Mr. Joyanthan Chatterjee, learned counsel, appearing on behalf of the state, submits that this court, at the time of passing of the order, has considered the prayer of the petitioner and directed the bank authority to transfer the petitioner from Bhubaneswar to homestead. It is further contention of Mr. Chatterjee that the order was passed considering the physical ailment of the petitioner, and this court has also considered the policy of request transfer formulated by the bank. Full stop. Mr. Chatterjee further argued that after passing of the order, the present petitioner was transferred from state of Odisha to the state of West Bengal, but he was posted in the remote place of district Murshidabad. Sometimes he was posted in Behrampur. Thereafter, within 3 months, he has transferred twice. It is the further contention of the petitioner that, considering the present physical condition of the petitioner had to prefer an application before this court for contempt act of the bank authority. It submits that the bank authority has not followed the direction of this court in its true letter and spirit, but only transferred the petitioner from state of Odisha to the state of West Bengal. Mr. Chatterjee specifically argued that that the petitioner was posted in a remote village of district Murshidabad, from where his medical treatment could not be possible. At this specific physical condition, he may be posted nearby to the district of Calcutta or nearby to his home station, so that his treatment may be done properly. It is the utter request of Mr. Chatterjee that the petitioner's representation dated 23rd of September 2024 was not considered, so he may be transferred to a place where from his treatment may be done. Learned counsel, appearing on behalf of the bank authority, has placed a compliance report on affidavit. They have specifically stated that after passing the order of this court, he was immediately transferred to Umranpur branch under Behrampur regional office, under Kolkata circle office, thereafter he was again transferred to the Behrampur regional office, wherein he could not sustain the workload and made several representations before the authority. Accordingly, he was again posted to one place, namely Jahangirpur, under the same region, where his workload is less. It is the further contention of the bank authority that near Jahangirpur there is a multi-specialty hospital wherein the treatment of the petitioner can be done. It is the fair contention of the learned counsel of the bank authority that the bank authority has complied with the order of this court in its true letter and spirit. So the contempt application is liable to be dismissed. having heard the learned counsel for the parties, in considering the impugn order, application for contempt, as well as the report of compliance on affidavit by the bank authority, it appears that this court has passed the order in favor of the petitioner so that he may be transferred from the state of Odisha to the state of West Bengal. Full stop. At the time of passing the order, this court has observed the physical condition and ailments and the suffering of the petitioners due to different disease. Full stop. It further appears that this court has specifically directed bank authority to manage the hurdles of administrative requirements and exigencies. It is true that this court cannot overview the hurdles of the bank authority and their administrative requirements. It is the pure domain of the sole domain of the bank authority. Where they shall post the officers, where they shall appoint stroke post the officers to perform their bank business. It appears that the petitioner is a manager of the bank and having a responsibility rather than the other officers. At this juncture, it appears that the order of this court has been complied with by the bank authorities by transferring him from state of Odisha to state of West Bengal. However, the bank authority should have considered the case of the petitioner sympathetically, but from the affidavit of compliance, it appears that the bank authority had to posted the petitioner in the Beharampur circle, in the Beharampur region under the Kolkata circle for the administrative requirement. I make it clear that this court has not passing any order in respect of specific direction to the bank authority to transfer the petitioner in or within the vicinity of Calcutta, but I am only passing an order to the authority so that the case of the petitioner may be considered sympathetically. In this case, it appears that the petitioner has made a representation to the authority. What is the date?
September.
No, 29th of May 2024. Page number, no, it is again. Page number 20 of the affidavit in reply. But here, last representation was 8th of August 2024. Page 46, then page 56. Oh, page 66. 44 and 66.
66?
Yes, my lord. 22nd November
22nd of November 2024.
Yes.
What is your prayer there? Again, residential house. Very well.
Yes, my lord. My lord, here I have stated that I will be put in very difficult situation and it will be very hardship to me as well as my family members due to recent mid-academic transfers. As this transfer, my residence was around 450 kilometers away. My residence was 450 kilometers away from the place where I have posted.
Now you can be posted in a
My lord,
place
before
where
that,
your
my lord,
treatment can be done.
My lord,
This is
before,
only the
before that, my lord, kindly comes to
critical
page
emergency.
38. Before that, my lord, kindly comes to page 38. After passing the order by this honorable court, I have communicated this.
Yes.
Presently, my health, page 38. Presently, my health condition is being deteriorated and hence I am under regular follow-up and under domiciliary treatment in Fortis Hospital and Medica Hospitals, Kolkata. Therefore, I request you to post me in a suitable branch, stroke section near to my residential house at Barakpur to save my life sympathetically or humanitarian ground considering my health issue and hardship. Here, my lord, Barakpur.
You cannot fix a hospital to be like that.
This type of
There are several hospitals.
No, my lord, your lordship knows everything, my lord. This type of specialized treatments are not being done everywhere, my lord.
Statement. There are not the Fortis Hospital medical like that.
My lord,
There are several
those are specialized in kidney treatment, my lord.
Hospital that we have named
No.
object.
All right.
He is making a statement from the bar.
Those
He's
are-
not checking whether that hospital provides this.
My lord, those are
very.
I can come back and say I am not.
those are specialized in kidney treatment, my lord. Be that as it may, my lord. My lord, forget about Fortis and Medica. Nearby area. I am not praying for Barakpur, nearby area.
Yes, yes.
Grateful, my lord.
Sympathetically. First of all, in this case, it appears that the petitioner has made a representation to the bank authority on 23rd 7 2024 as well as 22nd of November 2024. On 22nd of November 2024, which was not considered. I direct the the respondent, the bank authority, to dispose of those representation under sympathetic ground and transfer the petitioner in a place where from the treatment can be done.
Grateful, my lord. Grateful, my
We'll also, my lord,
Grateful.
make a note whether
Under the above observation, the instant CPAN কি number আছে দেখেন
CC 16 of 20.
CC 16 of 2025 is disposed of.
Then we'll also, in the sympathy, we'll also have to give what are the treatments available at every
My
hospital.
lord, this has become a ego problem.
No,
my lord.
they have
My lord,
place.
which, my lord, which representation will be considered, my lord? Which
Two
date?
representation.
November, which are
July and
post my lord's order.
Yes, of course. Post your lordship's order.
So there could not have been non-compliance.
No, I am disposing of that.
Yes, yes. Grateful, my
Grateful, my lord.
Okay.
Grateful.
Thank you.
Grateful,
Next.
my lord.
Yes, Mr. Suran.
Volume 2 to दिए दें. Yesterday I was placing the various conditions which have been incorporated in my agreement in regard to CAM charges.
Yes.
I was referring to clause 10.
Yes.
There are two more clauses I would like to place before Lordship, my lord, at page 121, my lord.
Place 120.
Paragraph 11, my lord.
Clause 11.
Clause 11, my lord.
Yes.
The recurring cost and expenses which may be incurred for upkeep, maintenance, and the operating expenses of all the facilities or the components thereof will be collected by the licensee facilities management agency along with the maintenance charges payable. Now, my lord, I have provided them a centrally air conditioned space. I need to maintain my central air conditioning plant. I need
air conditioning. Who placed the air conditioning system? You.
I have provided the central air conditioning. So for provide that is inclusive in my rate.
Yes.
But I am to maintain that plant, my lord.
Yes.
For maintenance of that plant, I need to expend money. That will be included in the camp charges, my lord.
Okay.
The firefighting system is there, my lord.
Yes.
Unless that is in operation, they will not be able to start that. Then I have installed electrical substation also. There electricity consumption was used 2000 kVA, they have said.
Yes.
So I have installed a separate transformer for them also. So all these facilities which I have provided, this needs maintenance, and for that they have to pay. This is what this clause states. Kindly come to paragraph clause 19, my lord. "19 is, my lord. Can I place, my lord?
Yes.
Clause 19 of the agreement at page 122, my lord.
Got it.
In the event the monthly license fee, taxes, or other dues remain unpaid by the sub-licensee for a period of more than 60 days, the licensee shall be entitled to terminate the sub-license granted hereunder forthwith by serving upon the sub-licensee a 30 days notice, whereupon the sub-licensee shall quit and vacate each and every part and portion of the scheduled premises, and shall hand over vacant and peaceful possession thereof to the licensee. In case licensee condones the default of the sub-licensee, then and in such event, the sub-licensee shall, along with such dues and or arrears, pay compensation for the loss and or damage suffered by the licensee, and also interest at the rate of 1.5% per month for the period of default on all amounts remaining unpaid. Even if I condone, I am entitled for interest, madam, for the outstanding dues. Now I would raise the award itself, my lord. The award is at volume 1, paragraph page 84, my lord.
Award page 84.
Page 84, my lord, of
Yes.
my petition.
Yes.
My lord, in short, I will submit why I am challenging this. The award has been passed as per my assessment.
Common area maintenance nil.
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 Absolutely nil. My claim was 1.71 crores and I have been paid nil.
My common area maintenance 1 crore 27 lakhs 17,534. Okay.
There are express conditions which I placed before your lordship.
Yes, just proceed.
Now, as per my assessment, the rejection is on the ground. I have come to conclusion, claim is dubious and contrived. And as per omnibus provision contained in Annexure D to the agreement, claim is not tenable. Now, my lord, this is not a ground of rejection. There are express conditions. Annexure D, it's an annexure. An annexure cannot form a part of a main contract.
What annexure D?
My lord, in annexure, it is stated this is to be done, this is to be done, this is to be done, and I will bear the license fee. And at one point, it is stated that they will also bear the license fee. The maintenance charges. Let me place it before your lordship.
Annexure D.
Yes, my lord.
Annexure D of the agreement.
Yes, my lord. It is at page 135, my lord.
Yes.
Now, first of all, my lord, I would say an annexure cannot form a part of an express condition. Express conditions can be supported by annexure, but then annexure cannot support the express conditions.
Yes.
Cannot override the express conditions. But I would not refer to entire one. Kindly come to this paragraph 6, my lord. At the bottom, paragraph 6, there are two 6, the lower portion of 6, my lord.
Yes.
Maintenance and upkeep of all utilities, whichever are provided by the licensee as per detailed specification schedule at the cost of sub-license. I will have to maintain it. But for maintenance, I need money and it has to be reimbursed by them. As simple as this. And on the top portion also, so and so will be maintained, I will be at the expenses, so and so, I will pay the expenses. No, ultimately I will claim it in terms of my express conditions provided in the contract, you know.
At the cost of sub-licensing.
At the cost of sub-licensing. Now I'll place the award before your lordship now, my lord.
Yes.
Paragraph 46, my lord. The provisions entitling the claimant to the claim common area maintenance charges are to be found in clause C2 read with clause E9, which I have placed yesterday of the agreement, which read together makes the sub-licensing the respondents to pay the maintenance charges on actual rates charged by the concerned authority. This is the finding of the arbitrator. Concerned authorities contemplated in the agreement was a service company or an agency to be called Facilities Management Agency. As I have said, since Facilities Management Agency was not appointed, I was providing those services. Apparently, there had been no such service company or such agency appointed or entrusted with the task of carrying on the work of maintenance. It should be made clear that dispute relates to maintenance of common areas supposed to be carried out by the claimant as opposed to day-to-day maintenance of the scheduled premises, which was the responsibility of the respondents. So as far as the internal maintenance of the premises was concerned, it was their responsibility. And they used to collect common area maintenance charges, including electricity charges from the various retailers who were posted over there.
Yes.
And as far as outside was concerned, I was liable to provide the maintenance. Naturally, no bill for maintenance was ever raised with any particularity or in a routine or systematic manner. But I have provided sample bills also. Still, it is said. And these are the disclosure of documents. I will refer to page 24 and 25, my lord. Ashok, it's not that?
24.
24 and 25. These are the two sample bills I have produced before the learned arbitrator. Now, item number 1 is, my lord, license fee. At the rate, that is at the rate of 21,84,605 per month for 1,01,031 square feet at the rate of 1950 per month for 36 months. From February so and so, 7,86,000. They have not paid, so I have included them. Now, add camp charges at the rate of rupees 1,68,046.50 per month so and so area for 36 months, 60 lakhs. If your lordship kindly come to page 25, the same thing will be there. The amount will be different because of the change in period.
Yes.
So like that, I used to send them the bills for common area maintenance charges as well as for license fee.
Okay.
Ultimately, they communicated to me, my lord. Since in terms of the agreement, you have advised us to make the payment of license fee to the bank, you need not to send us the bill also. We will send payment directly to the bank. I said, okay, no problem. It happens, my lord. It happens in every school these days. I authorize my bankers to collect, and my bank has issued a power of attorney also, which was signed by all the parties, and accordingly they used to make the payment. But
Yes.
still they did not make the payment. Now, again, on page 84, my lord, of the award. Naturally, no bill for maintenance was ever raised with the particularity or in a routine or systematic manner. What I have done, I have placed before your lordship.
No.
The claim
So,
for maintenance
whether
made by
whether you raise any bill,
this is bill, my lord, it was sent along with the letter. This is the statement, my lord. This is the statement, and the relevant letter is also there in the annexure. I will produce before your lordship.
yes.
I will produce before your lordship.
Okay. If these bills were raised actually.
I have raised my bill. These two statements were sent differently on different dates, along with a covering letter. That please find enclosed here with our bill for license fee as well as for maintenance charges. This statement was enclosed along with our bill.
Okay.
I'll produce those documents before adoption. Naturally, no bill for maintenance was ever raised with any particularity or in a routine manner or systematic manner. The claim for maintenance made by claimant in this reference is somewhat capricious and arbitrary. Now, if it is capricious and arbitrary, it must be specified how.
It has said the referred ignoring the provisions of clause C2 and E9 referred as above. What is this?
Below C2 and E9, C2 says it is a covenant of the sub-licensing that I will pay the CAM charges. And E9 says unfettered commitment. I will pay you the CAM charges.
Yes.
But something wrong, something different has been stated. Let me place E9, not before your lordship. C2 and C2 is at page 116. I'm sorry. Yeah, C2 is at page 116, volume 2, Mina.
Yes.
Sub-licensing covenant. It is a covenant of the sub-licensing. What they say? To bear the maintenance charge. I'll not read subsequently. To bear the maintenance charge. It is their commitment, my lord. And I come to clause 9, my lord. At page 120.
Clause E9.
Yeah, that is A, B, C, D, E. This is clause 9.
100?
120.
120. E.
9.
9.
Yes.
It is understood. Yes.
It has been understood by the sub-licensee that the maintenance of the said complex and or scheduled premises shall be carried out by the service company or agency who will carry out such maintenance and shall be entitled to collect the maintenance charges from the occupants thereof, including from the sub-licensee on proportionate basis, and the sub-licensee hereby gives its unfettered consent to the same. What more can I state in the agreement, my lord?
Yes.
And it has been signed by them. It has been read by them. It has been examined by them. The claimant sought to support his claim in this regard on the basis of loosely worded phraseology used in clause E10 to, sorry. The claimant sought to support his claim in this regard on the basis of loosely worded phraseology used in E10. But this is not a loosely worded. Let me place E10 also before your lordship. That is also at page 120, my lord.
Yes.
The sublicensee shall be provided electric connection up to their main panel, and therefrom subsequent distribution of line and other related work shall be carried out by them after obtaining the approval of their detailed layout plans from the licensee. I was required to provide one connection to their LT panel, and then internally in the premises they will do when I approve their design and everything. The sublicensee shall bear the electricity charges for their in-house consumption. For housekeeping, maintenance, air conditioning, outside advertising, water supply, etc. So it has been stated what are the electricity charges have to be borne by them. The sublicensee shall pay the charges on the quantum of power it requires from the sublicensee within 10 days of being called upon to do so. Now, if I raise a bill, they are bound to make the payment within 10 days. And shall bear the proportionate cost of drawing the bulk power supply from the board. Well, the power supply was brought from around 6 kilometers away. This is the railway land, my lord. I am situated here. The entire land belongs to railway. Railway said, Mr. Surana, I cannot give you power. I don't have power. You have to make your own. So I spoke to WBSCP and they agreed that we will give you from our substation. That substation was around 5 to 6 kilometers away. So I will have to provide necessary infrastructure work. That involved a lot of expenditure. So this is the proposal. Assuming I spend 1 rupee there, I will not claim 1 rupee from them. I will claim proportionately. Now say I was constructing 3 buildings. So 1/3 they should be here.
Yes.
It shall be the obligation of the sub-licensee to draw the distribution lines from their main panel as per the approved plans. The licensee facilities management agency will bill the sub-licensee for such metered electricity consumption on actuals every month, which the sub-licensee shall pay within 7 days of its presentation without demur, and shall also be liable to pay and clear the maintenance charges as may be levied by the licensee or the facilities management agency on proportionate basis within 7 days. But I have made it very clear. You have to pay maintenance charges on a proportionate basis for an area under your occupation, and when you have to pay. Now, it cannot be called a loosely worded. It's absolutely neat and clean, my lord. This is a commercial document. This is not a statute.
Yes.
The claimant, again, my lord, on the award at page 84, absolute at the bottom, the claimant sought to find his claim for maintenance with reference to the provisions in his agreement with the railways, being the agreement dated 16th April 2004, both for the purpose of defining the liability and calculation of the same. Page 403. Well, this is unfortunately, I mean, this is a railway agreement, but unfortunately, it has been annexed by them in parts. The earlier portion is earlier. So I am placing the relevant portion. The relevant portion is at 403, my lord. Absolutely the bottom, my lord. This is an agreement executed between me and railway.
Yes.
the cost, and hear me, Lord, the railway is the licensor and I am the licensor. And whoever I appoint, they will be called sub-licensing. The cost of maintenance of the developed commercial space shall be shared by the sub-licensee in proportion of the area under their occupation. The sub-licensee shall contribute an amount of ₹10 per square feet per month, payable in advance for 6 months, forwards towards the maintenance fund. Any shortfall of the funds for maintenance shall be met through the corpus fund. So I was required to pay 10 rupees per square meter, that comes to be 1 per square feet, to the railways. And here they say that sub-licensee shall bear that. They are my sub-licensee. And I have very categorically stated that this, whatever is stated in the railway agreement, will be applicable to you. And that is in clause number 25 of the agreement below, which is at page 123, my lord. 123 of my petition, volume 2, my lord.
Yes.
My lord, here,
Clause.
the last two lines are relevant, my lord. The sub-licensee shall always be bound and guided by the terms and conditions contained in the license agreement between the licensor and licensee.
Page 123.
Page 123, my lord. Clause 25, my lord.
Clause 25.
Let
Yes.
me put the entire clause before your lordship.
Yes.
Take the right to use and occupy specifically granted herein for the tenure and subject to compliance of the covenants on the part of the sub-licensee to be observed and performed, and also the rules and regulations for the use and occupation as framed from time to time by the licensee and or facilities management agency engaged for the maintenance of the said complex and or the scheduled premises. The sub-licensee shall not have nor claim any right beyond what is granted hereunder unless specifically authorized. The sub-licensee shall always be bound and guided by the terms and conditions contained in the license agreement between the licensor and the licensee. That is the railway agreement. Before this agreement was executed, I have provided them the acceptance of my tender to them, which was granted to me on 18th of December 2002.
Yes.
And this copy of agreement, which was executed by me on 16th of April 2004. So they were aware of all these conditions, whatever are there. Again on the award, my lord, at page 80. My lord, it will be seen here also in page 114 also that these documents were given to them. At page 114, if your lordship can kindly see. Of the agreement, sir, 114.
Yes.
I'll read from here. And whereas by an agreement to develop dated 16th of April 2004, executed by the President of India acting through Additional Divisional Railway Manager, Southeastern Railway, Kharagpur, demised to Mahavir Construction, that is to me, 12 Pondville in Calcutta 1, for the purpose of building a commercial complex on a vacant land measuring 8.3 acres more or less. More specifically described under the first schedule, hereunder written opposite to Andhra High School on Jhargram Road, Kharagpur at Kharagpur for construction of an area of 2.68 acres more or less, and to hold the set larger premises for a term of 25 years commencing from the signing of the deed of license, to be renewed after expiry of 25 years for a further period of 25 years on mutually settled terms and conditions between the railway administration and the licensee. So they were fully aware of these conditions. Today they cannot deny that I am not aware of this. I hope your lordship has to attend a meeting.
Yes, we have a full court condolences there. Today,
Here I am on the award. So next day I will start from the award itself.
17th, Thursday.
Can it be on 16th also?
No, 16th is the Wednesday.
Wednesday, this bench takes up on Thursdays and Fridays. Huh?
On Thursday.
Thursday. Okay. Argument on Mr. Surana in person. Continues. Let the matter appear in the list on 17th.
On the top,
17th, it will appear first.
Grateful, my lord.
कितना नंबर है बोलिए कितना नंबर